Good morning, everybody. Happy Wednesday. Welcome to TCF Live, where hopefully today we'll have 50% less tech issues. We'll find out soon enough. Let's start our day in Michigan. Judge Anzalone.
Underwood. So I'm going to
stick
her initial.
I'm not Craig Rosencrantz.
Yeah, I know, because I'm not talking to you.
Sorry.
Give me 1 minute. I'll be right with you. So, Mr. Rosencrantz, I'm going to put Rhonda's initials after your name. And then as soon as she gets here, I'll bring you back in, okay? All right, I'm gonna pop you in the waiting room. Okay, so, all right, so Mr. Lape, you are Craig Lape?
Yep.
All right, so Mr. Lape, this is in the matter of Megan Lape versus Craig Lape, file number 23-50278DM. Mr. Lape, we're here on two things. One is a failure to pay child support. It states here you're ordered to pay $454 a month in child support. As of today's date, your arrearage is $12,080.10. This is your third show cause. The last payment we received was on September 30th of 24 in the amount of $119. So, sir, the maximum penalty for failure to pay child support could be up to 90 days in jail, and you are over the felony level. So the state of Michigan could charge you with a felony. Now, we also have a contempt of court for failure to appear for a show cause on February 2nd of 2026 when ordered to do so. The maximum penalty on that could be up to 90 days in jail as well. Mr. Lake, you do have a right to have an attorney represent you here today and in all subsequent hearings. If you cannot afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
No.
No?
No, I didn't do anything wrong. I didn't get a notification for a show cause. I never received any paperwork in the mail. You kicked me out of my house. You took my house and gave it to my ex-wife based on her saying. And now
Okay,
I have,
so
I
Mr. Lake,
got my job
Mr.
back.
Lake, Mr. Lake.
Yes.
All right, so Mr. Lake, I'm going to set this over to this afternoon and I'll see you back here later. Thank you.
I'm going to lose my job. I'm going to lose my job. I have to get out of here. I'm going to lose my job.
Mr. Lake, you have two choices. One, you can request a court-appointed attorney. Two, you can plead guilty to this today. So those are your options. But would you like a court-appointed attorney?
No, I'll just plead guilty. Let's get this done. I didn't do anything wrong. I was driving home from work. I just got my life back together and you guys fucking tearing it apart again.
Okay, I will talk to you later this morning. I don't have time for this right now. Thank you. All right, so Mr. Bowerman, you are represented by Mr. Malaro. Mr. Malaro, are you with us?
I am with you, Judge.
All right, I will appoint you to Mr. Lake. So Mr. Malaro.
Maybe I'm not with you.
No. All right. This is in the matter of the people of the state of Michigan versus Gary Scott Bowerman. We have multiple files, 25-22242FH. That's contempt in a pretrial. All of these are. File number 25-22243FH, 25-22277FH, 25-22469FH. and 25-22479FH. I have Salvatore Malaro appearing on behalf of Mr. Bowerman, and I have Isaac Sneed appearing on behalf of the people. So, Mr. Malaro, pretrial and contempt on each file. How do you wish to proceed?
Judge, may I have a quick breakout with Mr. Bowerman?
You may. So I'm going to open up that breakout room. Mr. Bowerman, you will get an invitation to join the breakout room. And go ahead and join that. You are on jail Zoom 1. Mr. Malaro, where'd he go? Oh, there it is. All right, go ahead and join that breakout room. Mr. Murphy. Let me see here. I have somebody on an iPhone. I'm gonna, yes, ma'am, you. What is your name?
Chelsea Leininger.
What's your last name again?
Leininger.
Okay. Yep, your attorney is Rhonda Underwood, so I'm going to change your screen name. Miss Underwood typically goes to Judge Olsaver's court first. We kind of rotate. I get Mr. Murphy and Mr. Malaro first, and the others go down there. So I'm gonna put her initials after your name, and then I'm gonna pop you in the waiting room, all right?
Okay, thank you.
You're welcome. Ms. Canizo, I have no idea when I'm going to bring Mr. Late back. It could be a couple hours, so we'll call and let you know.
Just call me. Thank you.
All right, thank you.
Bye-bye.
All right, Matt Murphy. So, Christine Korea. Hold on, Mr. Murphy. Let me find somebody for you. Michael Beck goes in. Jessica Miles. Oh, I have Jessica Miles, Mr. Murphy.
Yeah, could I speak during a breakout briefly?
Yep.
Thank you.
All right, Jessica Miles, go ahead and start your audio and your video for me, please.
Yes, hi.
All right. It's okay. I'm going to pop you in a breakout room with Mr. Murphy. Go ahead and join it. If you don't know how to get back, don't worry. I'll bring you back. All right. Okay. Oh, so far. Okay. I can't swim in court, they can't swim in court, so. All right, Mr. Murphy, let me bring Miss Miles back. There we go. It'll take her a minute. Oh, she's back.
Yes, I'm back. Hello, Your Honor.
Okay, so Mr. Murphy, how would you like to proceed on behalf of Miss Miles today?
Your Honor, Miss Miles is in the diversion program. From my understanding, she's going to be paying by the end of the month. I don't know if the prosecutors have a different word or anything, but I'm just going to ask for another adjournment. I think it should be resolved before the next court date.
Mr. Sneed, once you verify that?
Yes, no objection.
Okay, how far out would you like this adjourned, Mr. Murphy?
Well, I'd ask for at least 45 days, and then from there, whatever fits the court schedule best, if that's okay, if the prosecution doesn't object.
I can't believe 45 days. It still feels like 25. How about April 8 at 8:30 in the morning?
Yes, Your Honor. No, my office
Right.
do the stipulation order for that date, April 8th.
Yep, April 8 at 8:30. And Mr. Sneed, can you sign your name with permission?
Yes, thank you.
All right, Miss Miles, we'll see you back on that day, all right?
All right, thank you very much. Have a great day.
Thank you, Miss Miles. I'll be in touch, okay? Thank you.
All right, thank you.
I have Mr. Rakowiak in my waiting room, but I have one more in front of you. Is that all right? Okay, Mr. Murphy or Mr. Malaro, I'm back with Mr. Bowerman.
Yes,
Okay, what would you like to do?
Oh, well, I think what we're going to have to do, Judge, is we're going to ask to adjourn this matter. He's got numerous files. I would like to petition the court today to, if we can arrange some long-term rehab for Mr. Bowerman. If the court would grant that as a condition of bond, he has obtained trustee status. He's a hard worker in the jail. Every time I'm over there, him and the other like-clad inmates are busy working and doing well. And Mr. Bowerman has been in a couple of rehabs. He does very well initially. I think he needs something long-term. As this court's aware, people who have severe addiction issues don't necessarily, it doesn't take on the first try. I will say this, Mr. Bowerman always maintains contact with me when he's in any form of crisis mode. He calls me, which I think is a good thing. So that would be our request. And then if the court grants us an additional pretrial, I try to work these out with the prosecutor in some fashion. But I truly do believe Mr. Bowerman needs a rehab assignment, and so that would be our request, Judge.
Right. So, Mr. Malaro, I would totally agree with you that Mr. Bowerman always is attentive, stays in contact. I mean, last time he absconded, he was Facebook messaging me from Florida. But he's a model prisoner. He's well behaved. I mean, he is generally a very nice person to deal with, but he has a severe addiction issue, and he has absconded on me so many times. So I do believe he is a flight risk. That's not to say if he ever enters a plea that I won't consider a long-term facility for him, because I definitely think he needs it, because all of his issues stem from addiction. You know, other than that, he really doesn't engage in criminal behavior. So yes, does he need that? Absolutely. But he's probably absconded more than anybody else I've ever had in front of me, because, you know, once he gets out, he's not in a structured environment. So I do feel he's a flight risk. So unless Mr. Sneed agrees to release him to rehab, I'm going to deny your request at this time. Mr. Sneed?
That's not the position of the people at this point. I would like to inquire if Mr. Malaro received the global offer back on January 27th.
I don't see anything in any of his files. So,
Okay, can I send that to you this morning, Sam? Maybe we can resolve the case.
Right. Because I'd like,
you said something in January?
So why don't we do this? Why don't you email that to Mr. Malaro? I have time today. And Mr. Malaro, if you wanted, I could bring him back at the end of my docket if you think that talking to him might help to resolve this. But otherwise, I can set it over to my next available date is March 18. And obviously that gives you time to go meet with them. But if he decides he wants to avail himself of it, you can bring him in right away. I will accommodate.
I'm willing to push him to the end of your docket, Judge. Give it the old college try.
Okay, so Mr. Bowerman, I'm going to let you go. And then we will bring you back this morning at the end of my docket, okay?
all right, thank you.
Thank you.
All right, good morning, everybody. It's TCF Live, sort of, on a Wednesday. So yesterday we had trouble with StreamYard. A few minutes ago, my computer that allows me to switch between courts absolutely collapsed on me. So I'm going to put you guys on hold a minute. I'm going to try to do a hard reset on this thing and see if we can keep the stream going this morning. God created this week to test me. That is clear at this point. So give me a few minutes. Don't go anywhere. Let me see if I can get this corrected so we can continue with the stream. Hang tight. Okay, friends, I believe I'm back, and I believe things are working. I apologize, but I wanted to fix it before it got really, really bad, which is exactly where it was trending. Anyways, let's go back to Judge Anzalone, where it looks like Darth Maul has perhaps suddenly appeared in the bottom right there.
And he didn't appear. So I don't understand how that order got entered, and I'm not finding a competency report. Miss Adams, can you check the ROA to see if we received a competency report? Because I don't think we did, and I'm wondering if that order got entered by mistake.
So there's Judge, there's a note.
I can't hear you,
No.
Joanne. Hold on, everybody.
September 10th of last year, there's notes that the competency report was addressed and that he was uncompetent.
He was
That's according, it was received July 31st.
in district court?
This was a pretrial in your report on September 10th.
Okay.
And it says that competency report was received on July 31st, finding defendant competent. And
Do you have a confidence?
prosecutor Bagnetto and AD Glazier stipulated for entry of report.
So I don't have one in the file, and it's supposed to be in the, yeah.
I'm so sorry to interrupt. It also says they were still waiting for a report on criminal responsibility.
Okay.
Yeah, Judge,
So-
I got a note that says found competent in September, but waiting on criminal responsibility. And then there's a note from November that says the client did not receive any paperwork on that to go up there. So maybe it just needs to be rescheduled.
The criminal responsibility. Miss Adams, doesn't the forensic for competency go in the file? I thought
Yeah.
the competency, because it's not in my file. I know the criminal responsibility doesn't. All right, so Mr. Beagle, can you hear me? So Mr. Beagle's not responding, Mr. Malaro. So what I'm going to do is direct, you're probably going to have to I think that order is probably expired. You might need to do another order for criminal responsibility or motion for criminal responsibility report. And then make sure that Mr. Beagle gets notification of the date and time to appear once we receive that.
And Your Honor, maybe our client advocate can arrange transportation if that's an issue.
And I will also say that any mail that we've sent him to his address has come back. So if you're able to get a good address for him, could you provide that to Ms. Adams?
Yeah, Judge, we just have an email address is all we have.
Okay, so I'm going to set this over to April 1 for a pretrial. You can do the petition for criminal responsibility, and hopefully we'll have a date by then and make sure that Mr. Beagle gets there. So April 1 at 8:30, and you can do the stip in order to adjourn. Mr. Snake, can I sign your name with permission?
Yes, please.
All right, we're all set. Thank you.
Thank you, Judge.
All right, this is in the matter of the people of the state of Michigan versus Cody Isaac Allen, file number 26-22521FH, which is the time set for pretrial in this file. And then I have the extradition file 26-22515AX. That's just kind of following along with the pretrial. I have Matthew Murphy appearing on behalf of Mr. Allen. So, Mr. Murphy, how would you like to proceed today?
Your Honor, the plea offer from the people will be for Mr. Allen to plead to counts 1, 2, and 3 in this matter under the Homes Youthful Training Act, dismissal of the remaining counts, but admit all for restitution. However, restitution right now hasn't been determined. That will be determined. The ultimate amount will be determined at sentencing. We did, Mr. Allen does wish to accept that offer and plead guilty to those counts. We did sign a plea agreement for that and send it over just now. So again, he will be pleading guilty to count 1, motor vehicle unlawful driving away, count 2, larceny from a motor vehicle, and count 3, stealing, retaining without consent financial transaction device.
Okay, so, all right, an extradition file is a misdemeanor. No. Let me see here. Fulton County Sheriff. Oh, now he does have a felony theft case out of Ohio that warrant is issued.
Your Honor, from my
So-
understanding, Mr. Allen's well aware of that. I think he's already appeared on that before. His understanding of that
I'm
is,
I'm just saying that I don't know that it would impact the HIDA. I was just saying, I know there's a felony and a misdemeanor count in Ohio. Oh, it is Ohio stuff. He has a full beard. You look like 15 years younger now, Mr. Allen, now that you shaved that beard off. All right. So, did you email that to me, Mr. Murphy?
yeah, I just asked our staff to email it over to your court and the prosecutor's office as well.
Okay, let's see. Was there any sentencing agreement?
Just that it would be under
Other than-
HIDA. The sentence ultimately would be, anything further will be up to your honor.
Okay. All right. Anything else to add, Mr. Malaro? Or gosh, I am so sorry, Mr. Sneed.
No, thank you.
So, Mr. Allen, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, so you're pretty soft-spoken, so I'm going to need to make sure you speak up loudly, okay?
Okay.
All right, I have somebody from MDOC. Who are you bringing in today?
Caldwell, he is not up here yet. They didn't put a call out for him, but he's on his way.
Jason Caldwell?
I believe so.
Where are you?
Gus Harrison Correctional Facility.
Well, why is everybody telling me he's at Dawn Farms? So, Jason Lee Caldwell?
I just have a last name, ma'am. I don't have his first name.
Well, the only Jason Caldwell I had supposedly is at a rehab facility, not an MDOC.
I have it, James Anthony Caldwell. I found his name.
Miss Adams, could you look up that name? So I don't have anybody of that name, so let me see if he's somewhere here in our building, all right?
Yep. I appreciate that. Thank you.
No problem.
Good morning once again, everybody. It's TCF Live on a Wednesday. Nice to have you all here. Thank you for bearing with me as we solved our tech issues a few minutes ago. I think we're cooking with gas now. Hopefully, maybe. We'll see how it goes. It's been that kind of a week. Let's change it up, though. We'll stay in Michigan, but let's head over and say good morning to Judge Dad.
Issued January 6th of 26, it appears. Or actually, it was issued on the 15th, but on the 6th of January, they said you had a blight condition at your residence at 26771 Allen Road in Woodhaven. You have the right to an attorney. If you want one, I will provide you with one at public expense. Would you like a lawyer?
Just why figure?
That's all I have in front of me.
I just pay that thing.
It's a misdemeanor, and you're going to have to remove the blight condition.
Yeah, so I've got all that. I have another case that I had the blight ticket. I thought all this was like together with that.
Well, let's not get ahead of ourselves. You haven't been convicted of this. Do you want a lawyer, or do you want me to arraign you and send you to the prosecutor to discuss it?
Yeah, the prosecutor discuss it.
So you're going to waive your right to a lawyer right now?
Yeah.
On January 6th of 26, they think at 26771 Allen Road in Woodhaven that you had a blight condition. The citation's not very specific other than saying that. So That's all I can tell you. It's a misdemeanor punishable by up to 500 fines, 90 days jail, costs or all those. You understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes,
If you plead guilty, you will be given all those rights, and we're not going to have a trial of any kind. Do you understand that?
yes.
All right, so you waive your right to a lawyer still?
Yeah,
I'll enter a not guilty plea. Personal bond, you don't have to post any money. I'll give you a $500 personal bond. You can not leave the state without the consent of the court or violate a law. You must appear in court as directed. You go out there, John, take that to Woodhaven when you get a minute, and they'll call you. You're gonna go right outside the prosecutor's door there, okay? Do they have to sign in, John?
Yes.
You have to sign in out there then, okay? Thank you. This is the one with. Which one do you have, Mr. McCandless?
I have Mr. Hagar, Your Honor. Magar, M-A-G-A-R, I'm sorry, Magar.
Byru Magar, 26W841213. All right, good morning again. Your name?
Morning, Your Honor. Glenn McCandless, if you have Mr. Magar.
All right, so you're gonna plead to impeding on his behalf?
Yes, Your
The
Honor.
improper lane use will be dismissed, true?
True, Your Honor. Yes, Your
And
Honor.
you're authorized to enter this plea on his behalf?
I am, Your Honor.
To the charge impeding traffic, responsible or not responsible?
Responsible, Your Honor.
All right, please accept it. Improper lane use is dismissed. This is a commercial vehicle, $220, and I'll give them until the 25th to pay, okay?
Thank you, Your Honor. Have a good day.
You too. Thanks a lot. Take care. Raymond Hamill, 26W840317. Sadie,
They're coming in on Zoom, Judge.
what date is that? Heather, I got a court to school program, and I want to make sure that I get some people for that. It's in March, but can never start too early. Do you know what day that is, Heather?
I do not, Judge. I need to look at that.
Okay, no problem. Mr. Gilbert, good morning. This
Good
is
morning.
26W840317. Your appearance?
Good morning, Honor. Mark Gilbert, P71034 for defendant, who's obviously present with me via Zoom.
All right, sir, your name?
Raymond Hamill.
Okay, good morning to you both. Counsel, your client pled guilty to operating while impaired. On February 4th, he was referred for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
The report is in his hands or on the desk in front of him as we speak. We reviewed it this morning. It is factually accurate.
Okay, anything that you would like to say on his behalf?
Sure. I can actually quote my client. He came in this morning and obviously noting he's been cooperative with all this and very forthcoming, but I've never had a client put it this way. He said, "This is completely self-inflicted." And I mean, when he was in probation, he obviously took responsibility, but he continues to do so while he was with me this morning. This is a singular event. This is not obviously the probation accurately assessed his alcohol issues. This is not somebody who's a constant problem drinker. He's a 5-6 times a year drinker, but he absolutely owned up to the situation as it was. So I think we've got a good candidate going forward. I would ask the court to adopt the recommendation as it is. Both my client and I think it's reasonable and warranted.
Okay. Is there anything else?
I don't think anything further, Your Honor.
Mr. Hamill, would you like to say anything, sir?
No, sir.
8 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. So I'm going to go along with this recommendation, but you're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. In order that you attend a level 1 alcohol education program with the Victims Impact Panel, okay? I'm going to order 3 days jail, credit 1, serve 2, and I'll let you serve those by way of community service. So I'll give you 16 hours community service. And that is due by let's see. Yeah, April the 7th, okay? You have to have 16 hours done. Fines are $300, costs $375, $75 victims' rights fee, $50 justice assessment fee. Your total fines and costs amount to $800. Probation fees are $160 for $960. And then you have a screening fee of $60. I don't think there's cost of recovery in Woodhaven. You guys didn't talk about that at all, did you?
We did not, Your Honor.
1,020 is your total. You're getting away pretty light here, but you know what? You scored in category 1 on both the alcohol and drug use portion. That tells me you don't have a problem. So you may be eligible for early discharge. You get everything done in 4 months, you can apply for early discharge. Okay, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, sir.
Okay, can he pay all this today?
I believe he will.
Yeah.
I believe he will be at the court forthwith as soon as we're done.
Okay, so you can pay it, then go over to probation. They should be able to meet with you today. They are a little short-handed right now. But if not, they'll schedule your appointment for you to come back in and explain the order, all right?
Your Honor, you will have whiplash. He'll be there so fast.
Nice to see you, Mr. Gilbert. Take care.
Have a
Good
good
luck,
day.
Mr. Hamill. Thank you.
Thank you, sir.
Antanasia Brianna Dozier, 26W841212A and B. And could I have Mr. Davis, Ralph Davis, is he here? Have a seat at the table. Ma'am, come on up to the podium and tell me your name, please.
Antanasia Dozier.
You're charged with driving on a suspended. You have the right to an attorney. You also have a second charge of speeding. Would you like an attorney to represent you? Okay, I'll go ahead and arraign you, and then I'll send you to the prosecutor. On January the 8th of 26, it is alleged that you did operate a motor vehicle in the city of Woodhaven, county of Wayne, on I-75 near West Road at 11:57 in the morning. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs, or all those. 2 points would be added to your traffic record. You also have a speeding charge. That would be a 1-point violation. You're charged with 80 and a 70, even though he has you clocked as going is driving 90 and a 70. Do you understand that?
Yes.
Okay. Did you sign the advice of rights and read and understand these rights?
Yes.
Plead guilty. You'll be giving up all the rights. There will be no hearing or trial. Do you understand that? If you plead guilty at any time, we're not going to have a trial. You understand that?
Okay.
Do you?
Yeah. But what do that mean? Do you get like?
I'm just telling you, if you plead guilty today, tomorrow, in a week, a month, you're giving up your right to a trial if you do that. Do you understand that?
Yes.
If you plead guilty, we're not going to have a trial because the conviction would enter then when you plead guilty. And you'd be waiving the rights, the presumption of innocence, the requirement that they prove you guilty beyond a reasonable doubt, your right to remain silent, your right to cross-examine their witnesses, your right to bring in your own witnesses, your right to use the subpoena powers of the court to bring in those witnesses, and to testify or remain silent. Do you understand all that?
Yes. But I'm still kind of confused.
Okay, tell me why you're confused.
Okay, so if I plead guilty, does that mean I'm making it worse on myself?
No.
Because
Oh, wait, just slow down. Let's slow down.
okay. Because I don't.
You're gonna go, here's what I'll do. You said you waive your right to a lawyer. I'm gonna send you to the prosecutor.
Okay.
I'm gonna give you a personal bond.
Okay.
I'm entering a not guilty plea. You can go talk to the prosecutor, see what the prosecutor will offer you. If the prosecutor doesn't offer you something that you want, then you come back in here and tell me, Judge, I want to set up for another pretrial and I want a lawyer, in which case I'm going to have you fill out a petition for a court-appointed lawyer. And if you qualify because you're indigent, then I'm going to appoint you. Do you understand that?
Yes. Okay. All right.
If you have another question, go ahead and ask it.
Okay. But if I plead guilty, does that mean I just pay money or I gotta go to court again? Do you get what I'm saying?
If you plead guilty, I'm probably going to sentence you.
Oh, no, I'll just see a prosecutor. Sorry, I don't know, like, you making me confused by saying.
Why am I making you confused? I'm not going,
I don't know what you're saying.
what part don't you know? Do you understand the possible penalties? I have to tell you what the maximum penalties are.
Okay, what's the maximum?
Up to 500 fines and 93 days jail and 2 points on your record. If you pled as charged to driving on a suspended.
Okay, yeah, no, I'm see the prosecutor because I didn't know my license was suspended. So I'm just gonna see what I can do.
Well, I wasn't encouraging you not to see the prosecutor.
No, I know, but you making it more clear to me, so I'll just see them and then come back.
Go out and
Okay.
talk to the prosecutor, see if you can work something out. If you can't, come back in here. Either way, you're coming back in front of me though, okay? Thank you. Davis, Ralph Davis, Ralph Otis Davis, 26W41234A, B, and C. Your name?
Otis Davis.
You have drive while suspended, drug paraphernalia, and improper plate. You have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer? I'm going to go ahead and arraign you and send you to the prosecutor on January 7th of 26. The police think you were operating a motor vehicle in the city of Woodhaven on Allen near West at 11:55 p.m. They think you had a suspended license that is a misdemeanor. It is punishable by up to 500 fines, 93 days jail, costs for all those. You also have a drug paraphernalia charge. That's punishable under local ordinance by up to 500 fines, 90 days jail, costs for all those. You understand that?
Yes, I do.
You also have a third charge of improper plate, which is punishable by up to $100 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes, I do.
And did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. Do you understand that?
So,
Do you understand what I've said, though?
yes, I do.
All right. You still wish to waive your right to a lawyer?
No, I think I'll take a lawyer.
Okay. I'm going to enter a not guilty plea for you.
Okay.
$500 personal bond. You cannot purchase, possess, or consume alcohol or illegal controlled substances. Do you understand?
Yes.
You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll set you up with a court-appointed lawyer. He just needs the pre-trial, John. So you go out in the hallway, we'll set you up with your lawyer. Any questions?
No, sir.
All right, good luck. Which case do you have, Mr.
Sir.
Mr. Holmberg, what case? With Jagus?
Yes.
Okay. Adriana Giselle Jagus, 26W84031. All right, good morning.
Good morning.
Ma'am, your name?
Adriana Giselle Viegas.
So we're gonna set this pretrial for 2 weeks out.
Just so the court's aware, I went to Brownstown Friday and today, before I came to court this morning, Alona said she was still downloading the dash cam and the body cam video, so I checked just so clear.
That's fine. We're gonna do the 4th, Heather?
Yes, Judge, we can do March 4th at 8:45.
Okay.
Thank you. And she's got proof of regular.
No, I trust you. She's been going once a week, right?
That's correct, Your Honor.
Yeah, so you just take her down the hall, get your new date. Ma'am, do you have any questions?
No.
All right, thanks.
So much.
Have a good day. Thank you. Mosgrove, Sierra Lynn Mosgrove, 25F244834.
She's on Zoom, Judge.
Okay. Ma'am, your name?
Sierra Musgrove.
All right, you got to take care of your tickets quicker. Can you pay this today?
I don't, honestly, I'm currently twins.
$53 now, ma'am. You can't just ignore a court like this.
Yeah, I know. That's why I called to get the the court's date in order to speak on why I even received the ticket. My car was parked at my son's bus stop.
I'm
And
not gonna go, hang on. I'm not gonna go back and revisit the ticket. You should have
Okay.
shown up back in October, okay? I can't revisit the ticket. There's nothing to revisit. You didn't show up and you lost. I'll give you some time to pay. I can do that for you.
I didn't know there was another court date. They told me this was the only one that was scheduled.
You didn't show up. You didn't call and schedule a court date, ma'am. We issued a show cause for failure to appear and pay.
I called to schedule the appointment, and that's when they told me this one was already in place.
This one of February 18th. We didn't schedule this until just a couple of weeks ago or so. January 15th, we scheduled this. You needed
Yeah,
to
I
call
never
the,
received anything about a prior court date.
because you didn't schedule one. They issued the ticket to you and you didn't do anything about it. The ticket was issued to you back on September the 30th.
Yeah, I called to get set up for a payment plan, and that's when they told me I had to come in to do the court date.
The court
But-
date's today. You didn't call for months. Okay, so I don't know what to tell you. I can't do anything about the ticket. If you want, there's nothing I can do.
Okay, so there's no like payment plan I could get put on for that?
No, I told you I'll do a payment plan for you, but I'm not gonna set aside the judgment that was entered because you didn't show up for 5 months.
That's fine.
All right. Do you have anything at all today?
I have nothing. I'm unemployed currently. I'm high risk with twins, so I'm bed rest pretty much.
Okay. Are you married? Do you have
No.
is the father in their lives? Is he gonna help you pay this?
I'm single. So I'm gonna have to figure it out. But what is the minimum payment plan?
You just tell me how much you can afford to pay and starting when.
I mean, realistically, nothing, but I mean, I'm gonna have to figure it out. I mean, whatever I could do, is it like monthly? I'm not sure. I'm new to this. I've never done this before.
I'll set up a monthly payment plan. How much can you afford to pay per month?
Would I be able to do like 10 to 20 bucks or something like that monthly?
Pay $20 per month, and I'll start you beginning March the 15th and the 15th of every month thereafter. How's that?
Okay, that's fine. And you said the total is up to 153 now?
Yes.
Okay, thank you so much.
Balance I'll reduce, but this is contingent on you paying the ticket. Balance reduced to 125, okay? Next time, be more adult about this, will you please?
Yes, Your Honor.
All right, good luck. So I'll reduce it to 125. You pay 20 per month beginning March 15th. If you don't have the money, no problem. Call the court. We'll go on Zoom and give you another extension. Don't ignore us though, okay? Good
Okay,
luck.
and now this doesn't affect anything with my license or anything like being suspended, correct?
No,
Okay.
no. Okay?
Thank you so much.
Good luck. Thank you.
All right, friends, let's change it up and go down to Florida and see what's going on with Wade Mercer today.
Ingram, Mr. Kennedy, good morning, gentlemen. You're here. I'm seeing you at the same time because your cases are identical for first appearance purposes. You're each accused of violating the terms of your state supervision. And in each case, the circuit judge assigned a no bond warrant. What I'm going to do today is I want to get you arraigned, which means I'm going to get you a lawyer appointed if you're asking for one, so we can get them started on your case. Mr. Ingram, would you like to have an attorney appointed to represent you?
Yes, sir.
All right, Mr. Kennedy, same question.
Yes, sir.
All right, I'm going to appoint the public defender's office to represent both of you. Listen to Mr. McDaniel. He's going to give you some information, and then I'll see if you have any questions.
Your Honor, we're going to hear plea of not guilty. Yes, set this in the March 5th pretrial docket, and advising both the attorney from the public defender's office to be about to visit them prior to that hearing.
March 5th, Mr. Mitchell, anything?
No, Your Honor.
So Mr. Ingham, Mr. Green or someone else from the public defender's office will see you before the 5th. That's the date you'll see Judge Garcia. Any questions, sir? All right, wish you the best. Mr. Kennedy, any questions?
No, sir.
All right, sir, wish you the best. Go have a good day. We have Madison Douglas next. Good morning, Ms. Douglas. You're here because you've been charged with, I think, 4 different charges. It appears you're accused of 2 third-degree felonies. These are on 2 different dates. One is fraudulent use of a credit card more than 2 times in 6 months, obtaining goods or money of $100 or more. The second third-degree felony is a counterfeiting of credit cards. Actually, there's 4 counts of that. Then you have another third-degree felony that's insurance fraud. Then you have 1 second-degree felony that's fraudulent use of a victim's of an ID of a person that's 60 years of age or older. So that's a total of 4, 5, 6, 7 different felonies is what you're accused of. I think you're entitled to a bond. I'm going to listen to the attorneys before I address that bond status. Mr. McDaniel, anything I need to know?
Nothing, Your Honor.
Mr. Mitchell?
No, Your Honor.
Ms. Douglas, I'm going to set your bond at $25,000 on the second-degree felony, and each of the third-degree felonies of bond will be a $7,500 based upon your history. You have 4, 5, 6 of those.
70,000, I think is the total.
70?
I think so. Might want to double check my math.
That's a large bond, Judge Mercer.
It is a large bond, ma'am, and your history is horrible. That's why your bond is the same amount as that amount, Ms. Douglas. So, Ms. Douglas, you have a condition of absolutely no contact with the alleged victim. I know that you're out on bond for trafficking charges in Leon County, drug trafficking charges, but this does not violate your bond, Ms. Douglas, because this allegedly happened before you were on bond there. So since this allegedly happened first, this can't violate your bond. Your bond does have a condition of random urinalysis. Actually, it doesn't, because then none of these are drug offenses. So I can't put a random urinalysis condition on there. I can only put a condition of no contact with alleged victim. Ms. Douglas, you'll get a chance to use the phone, ma'am, in just a few minutes and try to post the bond. I'm going to ask the jail to give you a notice for your court date. Ms. Douglas, your court date will be March the 3rd at 8:30 in front of Judge Garcia. Ms. Douglas, do you have any questions?
No, sir.
All right, ma'am, wish you the best. We have Grant Rossborough next. You need to check what? So there'll be 5 at, there'll be 6 at 7,500. Plus the 25, that'd be 70. Yeah, I think it's right.
So we got,
Mr. Rossborough, good morning. Mr. Rossborough, you're here. Hang on just a second. We're trying to get the bond straight on the last case.
8
I understand.
felonies? Or is there,
4, 5, 6, 7. The fraudulent use of a credit card, the way the jail has it written out, makes it look like that's 2 charges, but it's not. The fraudulent use of the credit card and obtaining goods, that's 1 charge. Follow me?
I only noticed that by the little space they give before the obtaining
There's
part.
no space, but so let's double check that. I'm pretty sure I looked at that this morning. Yeah, fraudulent use of a credit card more than 2 times in 6 months, obtaining goods or money $100 or more is 1 crime, not 2. Yeah, so the jail sheet's a little, they have some space, it makes it more obvious. Okay, so I think we're right on that last bond. Mr. Rossborough, good morning, sir. You're here because you've been accused again, possession of paraphernalia, possession of methamphetamine, and possession of controlled substance without a prescription. There is probable cause for these charges. I saw a prior very similar charge with a really unique dismissal because of statute of limitations is what it says. That was, I think the dismissal was last year. Perhaps
22,
before.
sir.
Well, 22 is when the charge happened, so the dismissal would have been in 23, I guess.
Yes, sir.
So, Mr. Rossborough, I think you're entitled to a bond, though. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
nothing, Your Honor.
Mr. Mitchell?
Just the standard random UA's condition.
Mr. Rossborough, I'm going to set your bond at the normal amount I'd set for someone that I don't offer a conditional release to. I'm not going to offer you a conditional release under these circumstances. Your bond is $5,000 on the 2 felony charges, sir, $2,500 on the misdemeanor. Mr. Rossborough, your total bond is $12,500, but it's cash or surety. Cash or surety means you don't have to come up with all the money, sir. You can go through a bondsman, Mr. Rossborough. I do not know if there's based upon what I'm seeing, the history, it looks like their inpatient drug treatment may be appropriate. If that becomes something he's interested in, Mr. McDaniel certainly will consider that and give the chance for a state to have input, a conditional release with inpatient drug treatment. In the meantime, he's got the right to a bond. You do have a condition of random urinalysis on your bond, Mr. Rossborough, because this is a drug offense that you're accused of. Sir, you're going to get used to phone in just a few minutes to try to post the bond. The jail's also going to give you a notice for your court date, which would be the 3rd of March at 8:30 in circuit court. Mr. Rossborough, do you have any questions?
No, sir, not this time.
All right, sir. Wish you the best.
Thank you.
Yes, sir. Kayla Davison. Ms. Davison, good morning. Ms. Davison, you have a warrant out of Lee County, Alabama. It appears that, the best I can tell, looks like a possession of controlled substance, perhaps a prostitution charge. I'm not really sure what all you have up there. They don't tell us anything about the bond, just that you have a warrant. I know that you've had a chance to speak to Mr. McDaniel about the waiver of extradition process. Do you have any questions about that process, ma'am?
No, sir.
And you're signing that document, so I'm assuming you want to go back and deal with these allegations against you?
Yeah.
I'm going to, Mr. McDaniel, she's doing this freely and voluntarily, right?
Yes, Your Honor.
Now, I can't tell from my jail sheet, ma'am, do you have any local charges pending, or is this the only thing you have?
It's the only thing I have.
Okay, so they'll be notified today that you've signed the waiver. They have 30 days under state's laws to pick you up, but we review the cases at 15 days if you're still here. The reason we do that is because we want to keep an eye on everything. So if you're still here in 15 days, you'll come back to first appearance, and I'll say, Mr. Jailer, what's the latest on transport? What have you heard? And the jailer will tell me whatever they know. If you've already gone, obviously I won't see you. There's a good chance I won't see you again, but if you're still here in 15 days, I'll see you and we'll see where things stand. Do you have any questions?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
Yes, ma'am. Tabitha Jones. Ms. Jones, good morning. Ms. Jones, you're here for one charge of possession, drug paraphernalia. That's what you've been accused of, ma'am. There is probable cause for that charge. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I talked with Ms. Jones. I think at this point in time, we just asked for maybe a cash bond or some kind of release option. I don't think she has anything, maybe except a honey fishing case, I believe, in Calhoun County from a few years
She's got a bunch of stuff in Alabama, or Georgia, but a lot of it was dismissed. It's really hard to tell in two different places.
I don't know if it's the same person. I don't know that. She told me she asked her if she ever been in trouble, and she said she had a hunting thing. That's the only time she ever been in trouble before. But have you ever been arrested in another state, ma'am?
I was arrested in Georgia, but all of my charges were dropped.
It's confusing because it says two different agencies. I spent some time trying to figure it out. Some of it says Hoboken Police Department, and that was May of 20. And then it says Brantley County Superior Court, and I have no idea if that's the same place or not. Were you arrested more than one time in Georgia? Let me finish the question, ma'am. Let me finish the question. Were you arrested more than one time in Georgia, or just the one time?
Just the one time.
And all the charges were dismissed, correct?
Yes, sir.
Okay. Did you have to do any kind of supervision for them to be dismissed, like a first offender program up there?
No, sir. I called to see when my court date was supposed to be, and they told me all the charges had been dismissed.
And that there's a bunch of dismissals on here. It's just, they don't have dates on the dismissals or case numbers, so it's not really clear. But I have no reason to doubt what she's saying. That's the only thing I see is Hoboken Police Department. And then in Florida, I don't know that this record shows anything.
I'm gonna say she had a hunting violation.
Yeah. I think, given that, I have no problem with the cash bond as long as the state does it. Mr. Mitchell?
We have no objection to a cash bond. We just request, no matter what the court decides, she be subject to random UAs.
Ms. Jones, given that, ma'am, I'm going to set you a $250 cash bond. You will have a condition of random urinalysis because it's a drug-related offense. Ma'am, that means that you can be drug tested. You likely will be drug tested on or even before your court date. So you've got a $250 cash bond. And I'm going to ask the jail to give you a notice for your court date, ma'am, which will be
This one's the second.
March the 2nd. March the 2nd at 9 a.m. will be your court date. And you've got that random urinalysis condition. Any questions, ma'am?
No, sir.
All right, ma'am. You'll get to use the phone shortly, ma'am.
All right, thank you.
Yes, ma'am. Ryan Barrington. Mr. Barrington, good morning. Mr. Barrington, you're here because you've been accused of, good morning. You've been accused of one count of driving under the influence. Mr. Barrington, I have read the complaint. There's probable cause for the charge. Mr. Barrington, I'm going to appoint the public defender's officer to represent you. What I'm showing is no prior record. Have you ever been charged with a crime anywhere?
No, no.
Great. That's good news. So I'm listening to Mr. McDaniel and we'll see where we go from here.
Your Honor, I spoke to Mr. Barrington. He's going to plead of no contest to a stipulated charge of DUI, less than .15, $1,078 in fines, 11 months, 29 days probation, 50 hours of community service, DUI school, minimum driver's license suspension. He'll be adjudicated guilty. And just let probation know that, he's a disabled veteran. I don't know, the 50 hours of community service. I don't know if he's going to be able to do them or not. They'll work with him, I guess. I mean, he is a disabled vet from the war, and that'll resolve that case today. He has signed his plea waiver form, waiving his right to a jury trial and call witnesses.
Mr. Barrington, the 50 hours of community service are required by statute. They're required by state law. But you also have the right to buy those off. The hourly rate, if you choose to buy them off, is $10 an hour. Is it $10? That's set by statute. So they haven't made that statute match minimum wage yet. So it's if you choose to buy them off, you can do that. If you don't, anybody can do that, even if they don't have a physical reason not to do the community service. Mr. Mitchell, is that all agreeable with the state?
Yes, it is, Your Honor.
And Mr. Barrington, do you have any questions about that agreement?
No.
Is that the plea you would like to enter, sir?
Yes, sir.
Mr. Barrington, I'm going to accept your plea of no contest to driving under the influence with a blood or breath alcohol level of less than 0.15. The judge you guilty of that offense under state law, sentence you to 11 months and 29 days probation, $1,078 court costs and fines, successfully complete substance abuse counseling, DUI school, 50 hours of public service work. And I do recommend the minimum driver's license suspension. If you choose AA, we're going to put a cap on it of 12 classes. Mr. Barrington, if you do enroll in the DUI school within 60 days, that does constitute your, that will satisfy your counseling requirement. Mr. Barrington, a couple of things. You may get off early. To get off probation early, you got to do half the probation and get everything done and stay out of trouble. There's a good chance you could get off at 6 months or perhaps 7 or 8, 9 months if you need more time to get everything paid. Mr. Barrington, the other thing is that I want to tell you is that the jail's they're going to let you use the phone, let you get dressed in your regular clothes, use the phone to set up transportation if you wish. Then they're going to bring you to the courthouse because the courthouse is where the probation office is at. When you get here, you'll meet with one of the probation officers. I think it'll be Mr. Goodson's case. Once Mr. Goodson meets with you and gives you a chance to ask questions, gives you a copy of all the probation rules in writing, you'll be free to leave. So if you do contact friends or family, you can tell them that you can be picked up in probably 30 or 45 minutes here at the courthouse. Mr. Barrington, do you have any questions?
No, sir.
All right, sir.
Your Honor, I forgot to put this on the
Ms. Hamer,
record.
a second.
I mean, I've already told him though, but Mr. Barrington, remember, while you're on probation, no alcohol or drugs. They will test you, you know what I mean? So no alcohol. And I explained that to you over and over now, no alcohol.
Yeah, Mr. Barrington, that's a standard condition of every probation case in Jackson County, not to possess or consume alcohol. So they're aware of that, okay?
Yes, sir.
All right, wish you the best, sir. I think that takes care of our first appearance docket. We have just a couple of our probation, our pretrial cases are out of custody.
Yes.
And they're not set till 9. Do you have any that are ready to do right now?
I have 2 of them ready.
Sergeant, anything else with the jail this morning that y'all need us for?
No, sir.
Do you have anybody that's waiting for this connection?
No, sir.
Mr. Mitchell, anything else you need Sergeant Gross or the jail for?
For the jail and first appearances, no, Your Honor.
Mr. McDaniel?
Nothing else.
So Sarge, we have 2 people on this docket for 9 o'clock. We're going to go ahead and stay on this connection since no one's going to be using it. And we'll see you tomorrow, okay?
I thank you.
Thank you.
March 9th.
We have a couple of our cases in the courtroom. Mr. McDaniel, just let me know who's ready, who you're ready on. Sir.
Shay Scheme, 25602 CT. I know she told me the same thing, so I was.
Ms. Skeen, come on up. Ms. Skeen. You're here in case 25-602 CT, charged with driving under the influence. Ma'am, listen to Mr. McDaniel and we'll see where we stand in your case.
Your Honor, we're just going to ask to set this in the March 9th pretrial docket. She advised me that she's going to be hiring an attorney, so I'm just kind of trying to get the case ready. I'm still working on it, but also anticipating another attorney.
All right. Ms. Skeen, give me just a second to see how old the case is. December arrest.
And we're still waiting on discovery on the case also.
Information was filed, I think, last Friday.
Okay. All right. So you're asking for a March pretrial docket?
March 9th.
Just a pretrial, not a trial docket? Mr. Mitchell?
No objection to that. I guess I can update. There was a discovery demand filed yesterday. We're working on getting a urine sample back from FDLE. They said it should be ready about maybe 2 to 3 weeks. So we should have it before that March 9th pretrial date.
Ms. Skeen, do you have any questions about what you just heard?
No. If I took the plea, would I be able to get off like probation 6 months early or whatever?
That's a standard option for people if they get anybody that gets, not anybody, but 90% of the people I'll let get off early, including you. You have to do half the probation, have no violations. That means you can't violate. You got to stay out of trouble and you get everything done. Here's where let me finish answering your question. Here's where it gets hard on DUIs. Florida law sets the DUIs fine very high. That's the highest fine we deal with in misdemeanor court. So some people need 7, 8, 9, 10 months to get everything paid. But to answer your question, if you can get everything paid at 6 months, it's certainly possible to get off at 6 months, although that's a lot to pay per month. But it's possible. Some people have everything done, but they need another month or 2 to get everything paid. If you can get everything paid at 6 months and you want to get off early and you've done everything you're supposed to, that's very
Get
common.
my driver's license back if I do that.
The driver's license is a more complicated question because that depends upon your criminal history, which I'm not familiar with. Mr. McDaniel, is this the first DUI?
I had DUI in 2011 when I was 21 that I was guilty of, but this I'm not.
I mean, she has one, driver's license, I can only assume did not like some of the mistakes that were made in the case. They did not suspend her license or license was not suspended.
Well, they're not suspended right now.
But when she pleads, she'll get a suspension on the second DUI of how long, Mr. Goodson?
No.
They didn't do it. They
couldn't
tried
unlock-
to do blood.
They couldn't unlock the cabinet and they couldn't figure. No, it's not a refusal. They did not.
I didn't refuse
You're-
anything. I did everything they asked because I had nothing to hide.
Hold on, Ms. Skeen. Your Honor, can I explain what happened in this
Well, I
case?
just want, the question Mr. Goodson needs to know is how the DUI was submitted and he can answer her question. So do you,
He pleads today, she'll either lose license for 6 months. Possibly a year, depending on what the urine sample. I would say my personal belief is she's gonna lose the license for 6 months based on the DUI conviction. She cannot get a business permit during that 6-month period because she had a prior DUI.
does that answer your question, ma'am? Because it's the second DUI. If you enter a plea to DUI, you can't get a business permit. And Mr. Goodson thinks you're gonna lose it for 6 months. If you wait on the results and the results come back on the lab test, it could change that answer though.
Can I talk to one for a second?
Yeah, I'll talk to her in a few minutes, Your Honor. We'll just come back to the case and,
Okay, so you want to talk to Mr. McDaniel, come back in a little bit? All right, we'll see you in a little bit then, okay?
Your Honor, we have Harvey Williams, case number 25489MM. I filed a notice in this case that he was out of town. He's had a doctor's appointment in Gainesville, but we got it set for trial this next week, bench trial. So
Yeah.
just we need to figure out what day it's going to be on.
Okay, State versus Harvey Williams. I believe I granted a motion to dismiss,
As to,
and there's still a null process in there, so I don't know.
You granted the dismissal and we did it that way, and then he filed a null process.
The null process is useless because the dismissal was done first.
to count 2 of disorderly conduct. I don't know.
That's the one I granted the motion to dismiss on.
Yes.
So once I grant the motion to dismiss, there's nothing left for y'all to dismiss.
Oh, okay.
The motion to suppress would be different,
I got you.
but a motion to dismiss, it was already done. So that don't even need to be in there, really. That's just confusing things. You know, if y'all can take that out, it needs to be removed. It's like dismiss, it's just dismissing a case that's already been dismissed. It doesn't. Yeah, that needs to be taken out. So,
That's on me.
so we've got one charge left. I know there were some conversations about a possible bench trial and I know I asked y'all, because I don't know anything about his criminal history. And so Mr. McDaniel wanted me to commit to no jail time. And I said, I'm not doing that without knowing more about the case. So have y'all talked about that issue at all before we set a bench trial?
I was not involved with the conversation. I mean.
You were
it's a
here in
motion-
court and we talked about it because you wanted to set it possibly for a bench trial. And I said, I can't commit to no criminal hit, no jail time. And then you actually sent an email afterwards.
Yeah, yeah.
Remember? Sent an email saying that you may appeal and blah, blah, blah. So
I don't know what conversation. I mean, he filed a motion, Your Honor, to set it for a bench trial for the rules. I was
he
not
being,
involved.
he being,
Mr. Mitchell did.
you know, the email I'm talking about?
Yeah, again, because I never seen the order on that motion, so I asked you, were you going to enter? the order on
No,
that?
it's not the email I'm talking about. The email that you sent out saying that you may be filing an interlocutory appeal if the judge wouldn't agree to no jail time. You remember that?
No, there was interlocutory appeal about the motion to dismiss, but I'll probably just go ahead and hear the case and then.
Okay.
So, I mean, that's what I.
So tell me about his criminal history before we go down this bench trial route.
I don't think he has any criminal.
Okay, if he has no criminal history, I have no problems.
Does he? Okay.
Here, I can have an NCIC pulled.
I see 1, 2, 3, 4, 5, 6, 7, 8 misdemeanors just on this one screen. I don't know what they're for. They're old. So
All in the state of Florida.
that's in our county.
Okay.
Now, there may be a bunch of worthless checks. I don't know.
I want to see if it's running it lower.
Okay. So, Mr. Mitchell, is the state asking me to agree to no jail time?
Yes, Your Honor.
I'm not doing it. Not unless you tell me something about him. I need to know something about his history. You're not going to put me in that box where you're taking away any authority I have to sentence him. So knowing that I'm not doing it unless you tell me something about his history, can you still compel him to go to, let me back up. My understanding is I don't have to agree to no jail time. That's the court's decision. So if I don't agree, you can no longer compel him to go to a bench trial unless I agree to not more than 6 months. Is that right?
I think that's correct. I mean,
So
John may be able to
if he
help.
files a motion that he did, then the court has to agree with that motion. It means no jail time at all, no possibility of jail time. Essentially, it'd be like a fine only case, there could be no jail sentence imposed.
Not fine only, it could be probation.
Yeah, it'd be probation, but he violates probation.
So if you want me to agree to that, you're going to have to tell me his criminal history, which you haven't done at all. So if you want to go forward with that motion, you want me to agree to that, I need you to.
I've got it pulled up right here if you want me to.
Okay, yeah, tell me what you got.
So
You have our circuit or you have his full criminal history?
I've got CSIS is what I'm doing. He's only ever been a Florida resident according to my knowledge from what I heard. So I think the last thing he had was 2015 was a controlled substance of cocaine. 2011 possession of marijuana.
Wait a second. Where was that at?
Jackson.
And how was it disposed?
Just as adjudicated guilty with Judge Gay. Let's see what he did. I apologize for my voice. It's a little messed up.
$2015.
It looks like he did 1 year and 1 day in prison.
That's the last thing you have?
That's the last thing. Yes, there were.
You don't see a 2023 cruelty to animals ×3 and a maintaining a nuisance that was dismissed by the state?
Yes, I'm going off of things that he's been adjudicated guilty for.
So given that he's already been to prison, I would not agree to no jail time. So we've got that issue resolved. Where does that leave us now? Is he wanting a jury trial?
Yeah.
Okay, so we'll pick a jury on Monday. And what day do y'all want to go to trial on?
I got a VOP meeting on Tuesday. Can we do it Wednesday?
Your VOP meetings happen during trial week.
That's Judge Garcia. Yeah.
Yeah, but you can tell Judge Garcia that's your trial week, and knowing her, she'd be more than happy to accommodate you. And we're not going to schedule a trial week around a meeting. If you had a trial in felony court, that'd be different, but
I got you.
A meeting, you can do it anytime. Okay, so I got 2 calendars in here. Okay, so you're looking at picking the jury Monday, and the state's request is to go to try it on Wednesday?
Yes.
Is there another bench trial that y'all were talking about?
On Thursday.
Is there another one besides that, though?
Oh, no.
The other bench trial you're talking about was this one?
Yes.
Mr. Williams? Okay.
Yes.
So Mr. McDaniel, what do you say about
Marvin
picking on
Martin
Monday and
would-
trial on Wednesday for Mr. Williams?
I don't have any objection to that. That's fine.
Okay, so I'm sure that I keep that whole week open, but let me just double check, make sure I don't have any kind of doctor's appointment or anything like that. Mike, at your age, I'll be going to the doctor all the time, don't. Okay, so we'll do that. That works for everybody. So we'll pick on Monday and trial on Wednesday. And if anything changes, I'll let you know about Friday, because my boss basically, we discussed it. He wasn't gonna be going to jail, so let's just wait till after. And he may not. I'm not saying he will. I just don't want y'all to put me in a corner on someone that's been in prison before. I may hear the evidence and want to put him in jail, and I may have the evidence inside he shouldn't. I have no idea.
I will go ahead and put on the record, my offer from the beginning has been 6 months probation. The one that I put out there with the $370 fine, restitution for the cost of holding the dogs, and, forfeiting, except for those other conditions I put on as part of the offer. I'll keep that offer open until Friday.
And then the forfeiting, there's something in there about fencing that would have to be done before the plea.
Yeah, that was kind of something I added in there as kind of an incentive to change that condition if he were to accept this offer.
Would it have to be done before the plea is my question. How would you verify it? You can't, I don't know what your plan is.
Yeah, I was hoping he would have it done before he did that, and I would just take that condition off, but
okay,
I'll keep the condition of forfeiting the dogs on there, and we'll keep
I'll be honest with you, he's
in his ways.
He's got fencing, he's got regular old 4-foot fence. I mean, it's around the whole, it's regular fence around it, and they're contained inside it.
But is it properly secured? There's patches where they've gotten out. That's the
Well, I know
problem.
they get out, they still get out, they dig out up underneath and stuff. I don't know. I mean, I don't know if he's got fencing. I just.
Yeah, I could send an investigator out there.
There's that one back. Okay, so we got that one resolved. Jury selection on Monday, tentatively to have a trial on Wednesday, and plea option ends Friday. And then we have one more case. I'm doing my docket. Lori Brown. Mr. McDaniel, you need time to talk to Ms. Brown and Ms. Skeen?
I think we can give them time. I'm fine with it.
We're going to take a recess because it appears I know Mr. McDaniel needs to talk to Ms. Skeen. He's talking to Ms. Brown now. So we're going to take a recess, ladies and gentlemen. We'll put the remainder of these pre-trials on the record and we regroup.
And just like that, he's done. But that's all right. I've got the next judge already queued up. Let's go say good morning to a certain Judge J. Cedric Simpson.
I'm sorry, sir. Please go ahead.
Good morning, Your Honor. Raymond Cook for the people. Your Honor, the people believe any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Thank you, Mr.
Morning, Judge. We likewise do not believe that any conflict exists, but should a conflict exist in any of the matters before the court today, we will waive said conflict and ask this honorable court to please hear those matters.
Thank you. Actually, they told me that you weren't here. No, I said, you don't have Ron Brown.
Okay.
I was informed of that. I said, okay, so just Torcio. He said, no, Torcio's not here.
No, I'm here.
So I said, oh, that's okay. Who do I have? And they said, Bowling. I said, cool.
But I'm here.
I know, so I'm disappointed.
Oh.
Is what I'm getting. No.
I'm glad to give him my seat, Judge.
Just trying to, I know, I'm just trying to lay it all out. The court for its part also does not believe that there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Matthew Nicola.
Morning, Your Honor. Raymond Cook for the people.
Brother Judge Torcio, Feaster, Assistant Defender on behalf of Mr. Nicola.
Sir, could you please state your name?
Matthew Nicolai, sir.
Thank you.
Thank you, Judge. I believe this is the file with the MOU, if I'm not mistaken.
Yes, there was a memo of understanding. I think everybody has signed off on it
I believe so.
here, and I'm prepared to sentence.
Thank you, Judge. My understanding is that Mr. Brown has reviewed everything with Mr. Nicolai. We've asked that the court follow recommendation and give an opportunity to show this court that he can be successful, Your Honor.
All right. Sir, is there anything you'd like to tell the court before I do impose sentence?
No, sir.
All right. On the count one attempted R&O, sentence of the court, 24 months probation, term with the supervision through the First District Court Veterans Treatment Court, $555 fines and court costs, which you'll have on the other count too. When can you get that paid, sir?
I can get that paid today, sir.
Wonderful. Pay that today. You're to comply with all terms and conditions as set forth by the First District Court Veterans Treatment Court. I'll order 365 days in jail. Credit 2, the balance is suspended. On the count 2 attempted R&O, 24 months probationary term with supervision through the First District Court Veterans Treatment Court, $555 fines and court costs. When can you get that paid, sir?
I can pay that today as well, sir.
Wonderful. Pay that today. You're to comply with all terms and conditions as set forth by the First District Court Veterans Treatment Court. 365 days in jail. Credit 2, balance suspended. All right.
Thank you, Judge.
Thank you. Well,
Thank you,
best
sir.
of luck to you, sir.
Appreciate it.
Let's call the case of the people versus Byron Blair.
Your Honor, Raymond Cook for the people.
And good morning, Mayor, Peace Court, Your Honor, Attorney Damian Cash, P number 85852 on behalf of Mr. Brian Blair. Mr. Blair, if you can hear me, state your name loudly for the record.
Byron James Blair.
Ready, Judge Torsia, Feaster, Assistant Public Defender, also on behalf of Mr. Blair on file number 2310991, Your Honor.
All right, thank you. All right.
Your Honor, at this date and time.
Go ahead, Mr. Cash. Apologies.
No, my apologies as well. At this date and time, I received this appointment from a withdrawal, asking for a new an adjourned pretrial, as this is our first contact due to situation that Mr. Blair appeared to be in, and so I need to get his contact information so that we can have further discussions, Your Honor.
So I believe
And
we're
also have all discovery.
I believe we're also requesting adjournment, Your Honor.
My next day. Adjourned to matter March 4th, 2026, 9 a.m. on both cases. As to the contact information and like, Mr. Feaster, you can supply that to Mr. Cash. Or I'll wait.
And Mr. Blair, if you can hear me, I emailed you. Please also respond to that email while we get this contact information.
You don't even know what I asked. Do you? No, that happens when I'm talking to bowling too. I don't listen to anybody. You'll supply contact information too. Okay. That was real simple. Thanks.
Thank
All
you,
right,
Your Honor.
thank you.
Sir. Have a good day.
We'll continue.
Bye.
Court calls the case People versus Albert Wilson.
Your Honor, Raymond Cook for the people.
Morning, Your Honor. Winter appearing on behalf of Wilson. I'm going to go to trial, so I'm substituting for it this morning, Your Honor.
All righty. And Mr. Wilson, you don't have, can you state your name first of all, sir?
My name is Albert George Wilson.
All right, you don't have any problem with Mr. Winter?
I'm sorry, I can't hear you.
You don't have a problem with Mr. Winter stepping into?
No, I don't. I don't have any.
All right, fantastic. Sir, how are you doing?
I'm old and fat and gray and ugly. I'm the same as when you last saw me.
Okay, you're right. All right, no, I'm kidding.
That wasn't nice. I knew I was going to get, I told you I was going to get brief.
Sorry, I didn't mean to say it that way.
How you doing, Judge?
I'm doing great.
Good.
All right, what are we doing?
We just get, if the court will allow us, we'd just like to kick this over so Mr. Amadeo can be here and work out an arrangement with the prosecutor. Please, sir.
Well, March 4th, what do you think work for him?
Can we push it a little bit further, please?
18th. March 18th.
That'll work.
2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Good to see you.
Yes, sir, you too. Court does call the case of the People versus Ricky Burdett.
Morning, Your Honor, bringing the cook to the people.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Burdett, who appears in person in front of you, Your Honor.
Yes, he's on his way up.
Okay.
Good morning, sir. State your name.
Good morning.
Your name?
Yes, Ricky Burdett.
Thank you. All right, what are we doing today?
Your Honor, it is my understanding that as of last hearing, my client was tendered an offer, that offer being a 1-for-1. So in that scenario, I did get a chance to talk to my client. He would actually like to plead guilty to the trespass, and in return, I believe the disorderly conduct would be dismissed.
Do I have a plea form? No.
I did not prepare a plea form. I was unaware that he was going to be pleading today. I can write that up right now. If we can pass the matter, I can get that done in just a minute.
All right. Sir, I'm going to pass the matter so we can write up the paperwork and then I'll take your plea. Okay? So go ahead and have a seat and then we'll call it right back up. Yes, sir.
And Your Honor,
I'll be called back.
yes, I might have sent an email to the wrong APA, so that's not his fault. That'd be my fault. I apologize, Your Honor.
You mean in terms of between you and Mr. Cook? It might be your fault?
Just telling him we were accepting the plea. That's probably my bad.
Oh, I realized it was I realized it was your fault. You didn't have to say it out loud.
Okay. Well, I'd rather just admit it. I feel better now, so I appreciate it.
Okay. All right. I'll pass it. We'll call it back up shortly. Court calls the case, People versus Megan Maxon.
Morning, Your Honor, bringing the cook to the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Ms. Maxon, who now stands to my right. Ms. Maxon, if you could state your name for the record, please.
Good morning, Megan Maxon.
All right. Good morning, Mr. Hall.
Good morning, Your Honor. Great to see you.
Good seeing you. All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of retail fraud in the third degree in a 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement of the prosecutor's deferred. There is also an indication of no restitution. That's the court's full understanding of the agreement.
That is accurate, Your Honor.
That's a correct statement, Your Honor.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
State your name, please.
Megan Maxon.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right?
Yeah.
Are you on probation or parole?
I am.
She is, Your Honor, but it postdates the date of offense. This should not be an issue for probation.
Has anybody promised you anything that makes you promised you anything other than what's been stated here today to get you to plead guilty?
No, they have not.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of June 4th, 2025, at the location of 7000 East Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan, what do you do at Walmart that makes you think that you're guilty?
I attempted to leave the store without ringing up floats and a coffee maker that were at the bottom of my cart.
Okay, so you were just going to push Pat. You were getting other things and just didn't ring those up?
Correct.
All right. Store was open to the public at the time?
Yes, it was.
You didn't have anybody's permission to do that, did you?
I did not.
And these items that you took out, these were items that Walmart had offered for sale?
Yes.
Ma'am, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
I'm satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence defendant's ordered to probation for a pre-sentence investigation and report. Sentencing in this matter will be March 11th, 2026, 9 a.m. Bond with its conditions will continue.
Thank you so much, Your Honor. Great.
Ma'am, on your way down, I mean, probation department is on the left-hand side. If you could stop in and just see them so we can start the sentencing process.
Okay.
I'll make
Thank
sure
you.
she gets there, Judge. Take care.
I don't trust. I told her. All right.
Okay, friends, we'll get back to court here in just a minute, but a couple things I wanted to cover. First off, for today, this will be a 3-hour show, not a 4-hour show. Just a heads up, Mrs. TCF, as many of you know, broke her leg some weeks back, and she's firmly in physical therapy now to fix that and get back to normal function. But it means for the next few weeks, every now and then, things are going to get a little wonky as we try to work that into our schedule. So 3-hour show today. So we have time to address that and other things. Also, I wanted to real quick address something that happened yesterday on the show in between all of our tech issues. You know, I did the sponsor read for Aura, and then somebody kind of popped off in the chat and made a real big assumption about that sponsor and tried to turn it into a political thing. First, let me say that Aura sponsors all kinds of different shows and different podcasts, right-leaning, left-leaning. I've seen them on cooking shows. I've seen them on a channel called The Fat Electrician, a guy who does history stuff, all sorts of things. What they typically do not do is sponsor a channel of this size. Generally, they're in that 100 to 500,000 up into the millions subscriber count kind of channels. Yet they found this channel and they took a flyer on us because they believe in what we do here. So I think that's important to note. They sponsor everybody, but not typically a channel this small, but they're doing it anyways. And I think that says something. But I do want to be real clear on something because I think it matters for this community. We're here to talk about law. We're here to talk about people, choices, consequences, stuff like that. And I'm going to share my thoughts because that's me. And, you know, I talk here a lot about faith and family, personal responsibility, because I believe those things matter. And I believe it ties into the cases that we watch and it frames those cases for me. And I'm not going to be shy about that. But if you need to fit me into some kind of a political box, you're going to be disappointed. Because you're not going to be able to do it. I'm more complicated than that, and we all should be. And, you know, there's a difference between talking about values and beliefs as opposed to turning everything into politics or sides, and that's just not something we're going to do here. I don't want people to start treating assumptions as facts. You shouldn't do that anywhere, and you certainly shouldn't do it here. Just because we had a sponsor yesterday who might have been seen on some right-leaning or left-leaning channels doesn't make them political. So, you know, whatever assumptions people get in their heads, it doesn't make it true. It just doesn't. And honestly, if we start operating that way, none of this is going to work. The courts don't work. The conversation we're having here doesn't work. This community and this channel does not work. We can disagree, we can debate. I encourage that here, you guys know that. But bad faith arguments and making leaps in logic like what happened yesterday, it's not what this channel is about, and it's not what we're going to do here. I want to make sure that what we talk about is real and that we're being honest about things and that we treat each other like adults. That's all I've got to say on that matter, and we'll move on from it from here. I needed to say that. Anyways, let's Texas, Judge Stevens.
Me laugh. That's it. All right, you're Gary Goodrow?
Yes, sir.
And Mr. Matuska is here. What are we doing here today?
Your Honor, I filed a motion to draw based on recent acceptance and employment with the Iowa Public Defender's Office.
Were you appointed on this one?
Yes, sir.
Okay. When are you going?
Beginning of this month.
Good for you. Good for you. I was there for 20 years.
Yes.
And a lot of great things can be done. With an aggressive office. And yeah, I know you're going to do fine. So, of course, what do we do? I mean, all of these, I'm certainly going to grant them unless some of this can be disposed of before the end of the month. This Boudreaux case, is this set for trial? Is that what we're doing?
I think they are, so the trials.
Okay, there isn't, you got a whole bunch of them, all of them set for trial. You couldn't try them all at one time, you know. There's all of these, this 4 pages.
Well, Mr. Boudreaux just says.
5, actually 6 pages, and there's no dispositions. 93% of cases are disposed of. 13 out of 14. None of these?
Not sure.
It's 35 cases. None are disposed. All right. All right. That's, well, we'll try these maybe in 100 years.
Judge, do we maybe also want them to do a plea rejection form? So that way the new council knows that the offense already been rejected.
Well, that's what we're going to do something to put on the record because people wouldn't believe that 35 cases, none of these can be disposed of. Nobody believed that. So we're going to put on the record so somebody can see it later. Yeah, that's what they did. They didn't want it. On Mr. Boudreaux, what was his offer? What you want?
45 years.
Okay. And you didn't want that, of course. Who would? But you've thought about it, and you know it's a murder case, so you're looking at up to life in prison if convicted. And then if you're convicted of this, you would, whatever sentence, you would have to serve 50% of the sentence before you were even parolable.
Yes, sir.
Okay, then life means you wouldn't be parolable for 30 years.
Judge, can we give defense counsel a minute to talk to him? I'm open to a counter offer to see if they have a counter offer to that.
Well, yeah, this is 2.5, going on 2.5 years old, though. How long have you been in jail? 2.5 years?
I'm on this one. This year make 5.
In custody, though. You've been in custody since the indictment in 23.
I've been in jail since
Are y'all able to talk about something, Ryan, or not? I know she said she was going to offer something, but I just hate to scramble around on the last day. All right, well, see what y'all can do. But he'll talk to you in a minute. Okay, sir?
Yes, sir.
Jerry and Elam. Jerry and Elam.
There you go.
Ashley, thank you for gifting 10 memberships. I surely do appreciate that. Helps bolster the community. Thank you so much. Very much appreciate it.
Gary and Elam, Mr. Matuska is your attorney. He is going to be taking another job with the federal government. You have 2 cases, 23 CR 740 and 741, 3rd-degree felony, deadly conduct, and discharge of firearm, and that 1st-degree felony of aggravated robbery. So up to 10 years in one case, up to life imprisonment on the other. You understand? All right. And on this one, can you put some on the record? So,
Judge, if you'll give me just a minute, I'm trying to see if the mandate came down on this. We had an MTRP hearing back in October 24, so I think it should be, but he got 50 years on an aggravated robbery, and I may get rid of the other cases. I'm just looking real quick. I haven't done that today.
all right,
Give me 1 second.
Just sit in the penalty box there and we're gonna check on that. Miles Horn. Mr. Horn. You're Miles Horn? Yes, sir. You've got two cases, 25 577 and 578. One is first degree felony of aggravated robbery. And the other is first degree felony of murder. You were looking at life imprisonment on each of these cases. And then because firearms were used in each of these, you would not be parolable until 50% of your sentence or at least 30 years had elapsed in service of your sentence. Is it just two cases here? Yeah. Mr. Matuska is your attorney who is going to be taking a job with the federal government. And so another lawyer is going to be here in replace of him, and then we'll move forward. What is, we want to put something here on the record. What was the attempt to dispose of these?
The state's offer is 50 years TDC, Judge.
In both of them? In both cases?
Yes, sir. That's my case.
That's yours? Okay, to run concurrently, not consecutive.
That's correct.
Okay. All right. Did you know that?
No, sir.
Okay. He's going to talk to you. And once again, y'all need to talk. And if you can't work something out, let me know. If you can, let me know. Okay. Thank you. Jimmy King. He's going to be back. Jimmy King is next, please. That's several cases here.
Real quick, while we're waiting for the next contestant, Granny, to address what you're talking about in chat. I wasn't trying to defend myself because I don't feel that I need to. At the risk of sounding arrogant, my space, and I'm going to run it the way that I feel it should be run and say what I feel that I should say. However, what I was doing was making sure that my interpretation of our ground rules that we're going to have here are very clear to everybody. And that's that we treat each other with respect. We're not going to make silly assumptions. We can debate, we can disagree. We've done it all the time. But I just want to make sure that everybody was clear on that.
What we're going to do is put it on the record. What the attempt was to try to resolve these without a trial. But what was it? What was that?
The state's offer is 20 years TDC, Judge, on the felonies.
All of them?
Yes, sir.
Run together?
To run together.
Okay. Looking at on the third case, it's a second degree felony enhanced to first degree felony punishment on 510. 511 is a state jail felony. 512 is a third degree felony enhanced to second. 51513 is a second degree felony enhanced to a first. So you've got state jail felony, third degree felonies enhanced to second, and 2 second degree felonies enhanced to life imprisonment. What was your offer again on this?
20 years TDC.
For all of this?
Yes, sir.
Have y'all talked about that?
Yeah, he's rejected it.
Oh, really? Okay. All right. Then we'll, what we're going to do is try the first degree felonies one at a time, and we'll just go one, then the other. As you know, if you're found guilty, all of those will be stacked on top of each other for punishment. Mr. Matuska is going to have to recuse himself now because and be released so he can take that other job. Another attorney will be appointed to replace him, and we'll go one first degree felony at a time. Okay, y'all get ready. That is all. No deals. This is, by the way, this is the last day on that. You don't have another. You don't have another option. This is the last day to accept that offer.
Yes.
Which is a lot less than what you're facing. All of these will be stacked if found guilty. All right, anything else? That is all. Get ready for trial. Well, who's next is Peter Lewis.
But Jimmy had.
Peter Lewis, that's you? Is that true, sir? 24 CR 1580, first degree felony of burglary. 24 CR 1759, first degree felony of burglary. These were intents to commit felonies. That's why it's first degree. 24 CR 1909, first degree felony. And 24 CR 1910, third degree felony, attempt to commit felony. Okay, so these are three first degree felonies, which carry with it up to life imprisonment on each case, and a third degree felony up to 10 years in prison.
Yes, sir. On the offer on the first degree felonies was 15 years to run concurrent.
Did you know that? That was an offer for 15 to run concurrently instead of life, then another life, then another life, then another added 10 years. So what was it?
15 on the first degrees.
Together, run together.
Yeah, run together, yes, sir.
Yeah, I think we might be able to.
See what you can do. Let me know, please. Today's the last deal. This is the last day. Mr. Matuska is going to be taking an. Oh, any important?
Didn't get to this.
Didn't get that. Charles McDaniel, I'm sorry. Jeff, that one. Lewis. Joseph Matthews. Yes. Joseph Gerard Matthews, that's you?
Yes, sir.
Case 24 CR 1602, you were charged with a second degree felony of aggravated assault. And there are 3 prior felony convictions out of this criminal district court in 2023 that have been added to
Makes
this
it first degree.
indictment. So, sir?
Makes it a first degree.
Yeah. So it is enhanced to a first degree felony. So you're looking at life imprisonment if convicted. You understand? Yes, you have to speak out so she can.
Yes, sir.
All right. Mr. Matuska is going to be taking a job with the federal government. And he's going to have to be released from representing you. But what we're trying to do is figure out if there's a way of resolving these things other than a trial. What?
My final offer was 12 years. TDC was the last offer I made. I'm not going any lower than that.
Have you had a chance to talk to him about that? Sir, I'm sorry.
I'm not taking to it yet.
Oh, okay. All right. Then the court will not accept any offer and is going to trial on this. There is no offer, no attempt to resolve this. Another attorney will be replacing him, and we will set this for trial, and we will accept no deals. Okay, that is all. Next is Jamal McCain.
Barbara, thank you for the $5 super chat. Continued prayers for Wahoo and Nina and their families. I totally concur. Thank you. And Great Granny, thank you for $2, echoing the same. Very much appreciate it.
Case is
One
on.
did show up on the judge.
I'm sorry?
One did show up on the docket.
I think it's the only one that.
So he had two cases. Okay, not a problem. You, sir, are Mr. McCain?
Sure.
Okay. Looking at three cases here, Mr. Matuska is going to be, he who has been representing you is going to be accepting employment with the federal government here shortly. So he's going to be moving on to the feds and I guess working in the U.S. Attorney's Office there, which is a great honor. And you have three cases. What we're trying to do is figure out if there's a way this can be disposed of. And the state has been making some generous offers this morning on these cases. But it's what you have is a choice. Either consider what they're trying to do to resolve this, or we just go to trial. You're charged with third-degree felony and 795 for tampering with evidence, and let's see, 266. But you have these three prior convictions that enhance this to a habitual felon. So you're looking at 25 to life, a minimum 25 to life, and 795. 23 CR 796, third-degree felony with the same prior convictions. It's enhanced to habitual felon. You're 25 to life on that. And you've got the first-degree felony of murder with the same three. Well, it's there's a fourth one added in here, but it still enhances it to a minimum of 25. So you're looking at a minimum 25 years imprisonment to life on each of these three cases. Do you understand?
Yes, sir.
So was there an attempt to try to resolve this to give him a thought?
I don't see an offer in Mr. Boyd's file, but listening to what he's charged with, I'd probably be willing to offer him 50 years.
And Your Honor, this has been a flexible case. It's been changing a lot recently.
How's that?
We've had some cooperating witnesses who have come out of the. So I think that's why.
What do you mean?
Got an offer yet.
Cooperating for
The state.
For the state?
Yeah. Some new statements have been brought to Mr. Boyd.
From defense or from the state?
For the state.
For the state, okay.
Yeah.
So that's still cryptic.
Well, that's
so, hey, that's why I said all of this. If y'all can't work it out, it just defaults to trial, and I don't accept a deal. Period.
Anyways, you're the backbone of this channel, my friend, and you've also become a very great friend to me and to everybody here. So I appreciate you. Just wanted you to know that.
You were Charles McDaniel? 24 CR 2477 is an indictment. You're charged with sexual assault of a child. It's a second degree felony. You have in the indictment. Prior conviction, all of this is found guilty beyond a reasonable doubt. That means you are looking at a minimum of 25 years imprisonment to life imprisonment. Mr. Matuska, who is your attorney, is going to be taking employment with the federal government here shortly. So he's going to be unable to represent you today in this case. Another lawyer will be appointed. Is that right? You weren't retained. You were appointed, correct? Okay. You're unable to hire a lawyer, I guess, still, correct, sir? Correct. All right. Then another lawyer will be appointed based upon the financial material that we have so far, which induces
You know, in
appointed
this case,
attorney.
I believe we're still waiting on some DNA. But it's been rejected so far.
Okay, what was there? This is the day that we're going to try to resolve if we can. If we can't, then it's default to trial. I don't accept a deal. And that's what I try, is that we try one after another here.
I'm looking at some notes from Mr. Boyd. He did not put an offer in here.
But note all those, no, there are no,
Yeah.
there are no
Yes, sir. I'm
deals on those other ones.
Yes, sir.
Judge, I can't tell what state. We're still waiting on some DNA, but there's also some talk about refiling this as a higher charge. So I can't really make an offer right now. And I'd respectfully request this one, maybe if you just appoint another lawyer and give us a little time, because we've got.
Okay, so
I
a
understand.
higher charge on the second degree felony. He's still looking, but habitual, no matter what it would be, habitual is still going to be a higher.
Right, but
is what counts.
There is though a charge that might be filed, and I don't want to say anything till I get it confirmed, that might require where he has no parole. So there's a difference between habitual with parole and habitual without parole. So.
Yeah, we need to talk about here.
Oh, sorry. Stand by. But that's not what's next on this.
Roger.
The next one on here is Jamal McCain. I don't have the file. Can't find it. Jamal McCain.
I'll keep an eye on Judge Stevens while they go find another contestant. Austin, thank you and congratulations on 5 months. Again, same kind of sentiments. You join us on Sidebar. Your value here is immense. You bring a different perspective with your work background and everything, and you've become a good friend. So thank you so much. Let's go back to Judge Simpson for a bit.
Fourth date, I think that should be. March 4th, 2026, 9 a.m. Bond continued. Thank you.
And I can stop dates if you want.
Yes, that's okay. I was gonna let you slide for a little bit. Clerk calls the case of the people versus Grant DeCia.
Ready-ish, Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. DeCia. I do not see him on Zoom, Your Honor. I do not see him in the courtroom. recollection is he was here a couple of weeks ago. We have a no contest plea worked out, is in the file. I'll be requesting a show cause, so we can get a plea.
Where is this show cause? Yeah.
Mike taught me that.
I got, yeah.
Yes.
Well, unlearn that. Potential warrant will issue bond 5,000. I'll give 10% privilege. That warrant will issue immediately. Thank you.
Thank you, Judge.
I'm not surprised we just do that one time. Court calls the case, People versus Michael Elkins.
Morning, Your Honor, Raymond Cook for the people.
Ready, Judge. Torshio Feast, Assistant Public Defender on behalf of Mr. Michael Elkins. Your Honor, we did reach out to Mr. Elkins by phone and text message. I do not see him in the courtroom. I do not see him on Zoom. I do not know why he is not present. For the record, I would request an adjournment.
Bench warrant, 5,000, 10%. Warrant will issue immediately.
I did not say show cause.
You did not. Court calls the case, People versus Sincere Godwin.
Morning, Your Honor, Raymond Cook for the people.
Brian Bowling on behalf of Ms. Godwin. Who, is she on Zoom? Rather, I don't see her in the courtroom. It doesn't appear as if she's on Zoom. I'd ask the court to adjourn this matter so that we can get in touch with her. I don't think we have valid contact information for her.
Bench warrant will issue bond 5,000, 10%. Warrant will issue immediately.
Thank you, Your Honor.
They're on a roll. Court calls the case, People versus Wilmer Hudson.
Morning, Your Honor, Raymond Cook for the people.
Oh.
Brian Bowling on behalf of Mr. Hudson is coaching. State your name for the record, please, sir.
Wilmer Hudson.
Thank you, sir.
Judge, I'm asking for an adjournment in this case. We did have a meeting scheduled with Mr. Hudson to review some video footage, but unfortunately, there was a bit of a technical glitch with the person who was going to review it with him. We couldn't get that accomplished. So we'd like to come back and get that after getting that accomplished.
You'll be able to do that by the 4th?
I believe we should be able to, yeah.
March 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you. We'll be in touch. Thank you.
Court calls the case, People versus Paula Johnson.
Morning, Your Honor, Raymond Cook for the people.
Brian Bowling on behalf of Ms. Johnson, Your Honor. You state your name for the record, please.
Paula E. Johnson.
Your Honor,
where have you been?
Here we go. You know, or should I stand? Here we go. Yeah, so where have I been? I've been in school.
How you doing?
I'm wonderful.
Okay, great.
I got a year or two before I get my bachelor's, so working hard at it.
Okay.
Yeah. This was just a glitch along the way, so.
Okay, but you're doing well otherwise.
Yeah, I'm doing really
okay,
well.
that's what I meant to say.
Okay, I know what you meant to say, but okay. We'll let that pass.
Okay,
anyway.
all right.
All right, Jan.
Okay, now that we've had our greetings.
I spoke to Ms. Johnson today, obtained a updated phone number for her, which we did not have a valid phone number until I saw her this morning. So I'd like to get an adjournment so that we can speak to Ms. Johnson and hopefully be able to come to a resolution of this matter.
Okay.
How long would you like?
How long would I like? It doesn't matter.
I wasn't asking.
Okay, give me about a couple of weeks then, a month, I don't know. What works for you, Judge? I'm just saying. What? I'm trying to be flexible here.
Yeah, well, you know. You guys have no idea this is going to be something.
See, you know,
no,
you know I am.
Every case has never been easy with you.
But now you know good and well that is not true. We have worked through this. We're going to work through this one as well. With no problems, hopefully. I know. You said I can't say that with a straight face, right?
We're working through. All right. Do you want the 4th or the 18th?
That's the 4th is fine.
We'll be here.
Yeah, there's no reason for you to be here, Mr. Bowling. Adjourn this out to March 2026, 9 a.m.
Thank you, sir.
And in all seriousness, Ms. Johnson, I hope that you're doing well.
I am. God bless you as well. All right, thank you.
Court does call the case, People versus Francis Judge.
Morning, Your Honor, Raymond Cook for the people.
Ready, Judge. Torshall Feaster, Assistant Public Defender, on behalf of Mr. Judge. Mr. Judge.
Hello, I'm Francis Judge.
Thank you, sir.
Thank you, Judge. Do you have a copy of Mr. Judge's driving record?
Do I? Yes.
Mr. Judge has indicated and provided the receipt that he paid his fees yesterday, and he should be valid. I don't know if you.
Oh,
I
so
have
you
my-
just did it yesterday?
Well, yesterday I got my license. Yeah. It says right on there.
That's not what mine says.
Well, that.
But you did that yesterday?
I was at the secretary.
Nothing like waiting till the last minute.
Well,
Miss Ann, can you, all right.
it took a
Let
while
me,
to pay
I
that
know.
actual obligation. I know it's been a long
Something on
time.
my face says, talk to me. No, just, hang on a second. We're just gonna, this was run a couple days ago, so if you did it yesterday, it's gonna show suspended, but. Hang on,
Just checking.
hold on, we're checking. No, I believe you. Put your wallet away. It's valid. Okay, you're valid.
Your Honor, people need to dismiss.
No objection, Judge.
Case is dismissed. All right.
I want to thank you for your patience and your understanding. Thank you, Judge.
You're more than welcome, sir.
Thank you.
All right, good luck. Drive safely, please.
Thank you.
Take care.
Thank
Good
you.
luck to you. Yes, sir. Thank you, Judge.
You started this morning. Court does call the case. People versus Alicia, is it Calloway?
Yes.
Huh. Okay. Ready, Judge Torshall Feaster, Assistant Public Defender, on behalf of the defendant. Please state your name for the record, ma'am.
Alicia Callowick.
Thank you. Judge, we did not have good contact information for Ms. Callowick. I'd be asking for an adjournment, and I'd ask Ms. Callowick to please call our office so we can make sure we have good contact information for her.
I
Oh,
have
adjourn the
called
matter,
the
March.
office.
Thank you.
You already did?
Yes.
Okay. March 4th, 2026, 9 a.m.
Thank you, Judge.
All right. Thank you, ma'am.
Thank you.
Court does call the case. People versus Noman Khan.
Raymond Cook for the people.
Ready, Judge Torshall Feaster, Assistant Public Defender, on behalf of Mr. Khan. Mr. Khan, please state your name for the record.
Noman Rahman Khan.
Thank you, Judge. I've been in touch with Mr. Khan pretty much every day by text message. We're still trying to negotiate a resolution. I've reached out to Mr. Cook, and I think he's considering it. I'd ask for a brief adjournment for his.
The last time we adjourned this, I said it was the last
Oh.
adjournment.
Okay.
I'll set it for
Set it.
jury selection and final settlement conference.
Sounds good, Judge.
Jury final settlement conference will be April 10th, 2026. 9 a.m. Jury selection if necessary, April 13th, 2026,
Thank you, Judge.
8:30.
Thank you very much.
Those are both in-person proceedings. Bond will continue.
Thank you, Judge.
Thank you. Are we ready on the recall? Recalls case, people versus Ricky Burdett.
Morning again, Your Honor, Raymond Cook for the people.
And good morning, Your Honor, to you and your staff attorney, Maxwell Dubin, P number 86012, on behalf of Mr. Burdett, who is approaching now.
Your name again, sir?
Ricky Burdett.
All right. I've been handed a plea form executed by the parties indicating that he will be pleading to count 2 of trespassing. The 30-day offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Is that correct, counsel?
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Ricky Burdett.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of trespassing. That is a misdemeanor punishable by up to 30 days incarceration and up to a $250 fine plus court costs. Do you understand that, sir?
Yeah, yes, Your Honor.
All right.
May I repeat that, please? That is both 30 days probation and $250 fine?
No, the maximum penalty on the charge would be up to 30 days in jail
Oh, jail.
or a $250 fine plus court costs. You understand that, sir?
Which am I getting? I'm
Well,
not clear on what I'm getting.
I haven't decided on that yet.
I see.
Okay, but you understand what the maximum penalties are?
Your Honor.
All right. And understanding that, do you still wish to plead guilty?
I do.
All right. And to that charge, how do you plead? Guilty or not guilty?
To that judgment?
Well,
Guilty.
to the charge of trespassing, how do you plead?
Guilty.
All right. Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Have you executed an advice of rights form? I don't see one. Counsel, did you go through an advice of rights form with him?
I did, Your Honor. And for the record, Mr. Bennett, those are the rights, your trial rights that you would be waiving here by accepting this plea. Do you remember that?
You remember that? Your attorney said that he went through your trial rights with you.
Yeah, yes, he did.
Okay. And that those were your rights, that the trial rights that you'd be waiving. You remember that?
Yes, I do.
All right. Look on the podium there. If you look on the podium, right here, right there where my bailiff's pointing, that's a copy of the advice of rights form. I'll let you get your glasses.
All right.
All right. And if you look at paragraph 5, those are your trial rights. You understand that you're waiving those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
All right. You understand you're waiving your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation?
No, I'm not.
No, okay. Are you on parole?
No, I'm not.
No.
Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, they have not.
Has anybody threatened you or coerced you in any way?
Say again?
Has anybody threatened you in any way to get you to plead to this charge?
No, they have not, Your Honor.
All right. You're doing this voluntarily and of your own free will?
Yes, I am, Your Honor.
And you're doing it because you believe that you are guilty of this offense?
Yes, Your Honor.
All right. On the date of January 15, 2026, location of 3153 Ann Arbor Saline Road in Pittsfield Township, that being Buddy's Pizza. What'd you do? Had you gone to Buddy's Pizza that day?
Since then?
No, on that date, back in January.
January 15th? Yes, I did.
Did they ask you to leave the premises?
Yes, they did, Your Honor.
Did you immediately leave the premises?
I left the premises after asking if I could question what I was being accused of.
Okay. So you did not immediately depart from the premises? I mean, at some point you left, right?
Yes, I did. After I was able to challenge or ask what I was being accused of.
Okay.
I was accused of threatening people, and I asked if I could repeat what happened the time I was there prior to and go through to see if indeed that was threatening people. And then the manager that initially said that I was threatening people said, well, you were not threatening people. You were loud and you were scaring people. And so he changed his mind on that. And then I did leave at that point.
Your Honor, with the court and defense counsel's permission, may I voir dire for the factual basis?
I could voir dire as well. I was gonna say the same thing, but he can voir dire.
Whoever wants to do it, go ahead.
I'll do it. I appreciate that, Mr. Cook. And Mr. Burdett, after you left, did you then return back in after being told you were being trespassed?
He said, did you, after you left, did you come back that same day?
Yes, I did. I walked out of the building onto the sidewalk and I immediately turned to the building and I immediately walked back to the bar and approached that same manager.
Okay, so just so that I have it right, okay? Because I have to make sure that there's been a crime committed.
Yes.
You
Yes, Your Honor. I will.
All right. You did leave. Well, let me back up. You were asked to leave and did not come back, right?
Correct. Yes, Your Honor.
Then you did leave, right?
Yes, I did, Your Honor.
But then you came back.
Yes, I did, Your Honor.
Gotcha. All right. Thank you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Absolutely, yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Sir, is there anything you want to say before I impose sentence?
Say or ask?
You, whatever.
Can I ask a question before I am finally dismissed? I want to be clear on after the judgment. I want to be clear on it.
On what?
Your Honor, I believe
if I'm getting probation after I serve the probation, am I free to leave the USA? I have an international passport. I just want to be clear on that.
I'm not going to put you on probation.
Just a fine?
That's what I was thinking. Do I need to put you on probation?
I don't even know if you've delivered the sentence to tell
I haven't yet, but I after listening to it, I don't know why I would put you on probation.
Oh, I was going by
doing something
I was
else?
going by that sheet I signed. I don't know if that meant both or just either or.
Oh, it's either or.
Either or, okay.
Okay, so I can put you on probation. I could send you to jail, or I could just impose a fine. So you want me to put you on probation? What are you telling me you want me to do?
Not necessarily.
Okay, I'm just trying to make everybody happy.
Sure.
All right.
I just, yeah.
Sir, are you gonna, the last time you were in here, you remember yelling at me? You don't remember that. That's okay.
Oh, trying to defend myself?
I don't know what you were doing.
Without counsel?
Well, right. Well, your attorney hadn't shown up.
Yeah.
And remember you were getting angry with me and I was saying, I gotta make sure your rights are protected, but you didn't like that for a moment. Remember that? Okay.
Yes, Your Honor.
So, as I'm listening to you, I also realize, I think you're an Army veteran, right?
Oh, Navy.
That's right, Navy, because I said I liked you because
Your Honor,
you're Navy.
my other
right?
client was the Army veteran, Your Honor.
Your other client was Army, the one I didn't like. Okay, yeah, you're Navy. All right. And so, I realize that you're upset because things weren't happening the way they were supposed to. And also, I got the impression once your attorney, somebody got here for you, you calmed down and you seemed to me to be a man of your word. That's how I viewed it. Okay. And so as I listened to this plea, I also realized that you're one to always want to make sure that the right thing's done. Am I right? Am I right about all of
Yes, Your Honor.
And so I don't think that I need to put you on probation. You realize you're not supposed to go back to Buddy's Pizza, right?
Ever. Correct.
Exactly.
Indeed. No,
And
that's completely fine with me.
I'm gonna trust you that you're a man of your word and that you're not gonna go back there. I don't think I have to put you on probation to make sure you won't go back there. So I was just going to impose a fine unless you want me to put you on probation and send you to jail. If you want me to, I mean, I can do that, but I don't think you want me to. Right?
I'll pass.
Okay.
Yes, Your Honor. Yes. So can I pay the fine leaving the building today?
Absolutely. We will be more than happy to take your money. Okay.
Was my question about you using my international passport? Did that make sense?
You asked if you can then travel. Once I finish here, the world's yours. All right?
Thank you, Your Honor. Yes.
You're welcome. Let me ask you this, sir. You're not working, right?
I'm retired. No, I'm not working.
You're
Correct.
not working. You just received retirement.
Pardon?
You receive a retirement?
Yes, I do.
Oh. Fines cost of $150. And I'll suspend 30 days in jail. You can get that paid today?
Yes, Your Honor.
All right. You can pay it up at the front counter. All right. Thank you, sir. Pleasure meeting you. You
Thank
take
you, Your
care of
Honor.
yourself. All right.
Thank you, Your Honor. Have a great rest of your day. I appreciate you greatly.
You do the same, sir.
Nina, thank you for the $10 you say for all you do. It's a pleasure to show up here every day, Nina, because of people like you. It's a good community. You know, we have our glitches every now and then, but this is the best thing I've ever done, and it's a joy to be here. So thank you. And if I heard correctly in the chat earlier today, it sounded like things went well with your son yesterday, and I was glad to hear that. Let's go back to Texas. 9 to 11% more Judge Boyd per our promise.
Court is calling 2025 CR 005635 State versus Angie Ford. Can I have parties announced for the record?
Dwight Chumley for the defendant, Your Honor.
And are you Ms. Ford?
Yes, ma'am.
All right, counsel, you received all discovery. Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Ford, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Yes, sir.
Both counts?
I'm sorry. State moves to waive count 2 and proceed solely on count 1 of the indictment.
Any objections?
No.
Ms. Ford, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. So you are charged in count 1 with theft of property, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Ford, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Oh, yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has state is waiving count 2. They're proceeding on count 1. Punishment is to be assessed at 2 years in the state jail facility. There's a $1,200 fine and no applications. Did you understand that to be your plea?
Yes.
Defense?
Yes, Your Honor, we also have agreed to run concurrent with the other case that's pinned. The motion to revoke this.
Is that correct?
Yes, sir.
All right, and state, is that the plea? All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that are heard and ruled upon by the court. Did you understand? Outside the agreement, the state is requesting that there be no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
No objection.
All right, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Your Honor, my client has been very cooperative. She was on probation with you quite a number of months. She received help at FEB, which she has told me over and over how grateful she is to have gone through that. This is on her pending MTR.
Okay.
And that she wants to thank you for letting her do that. And she spent 399 days, something at FEB. She's completely satisfied at her spot there. The day she finished it is the day she got picked up on the warrant for the new case.
Okay.
But life provides you rewards in other ways, and she's gonna really be great when she gets out.
Okay. So let me ask you all, is there any restitution that's owed or no? All right. Then the court is going to follow your agreement, sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $1,500 fine, time and money to run concurrently. There's to be no contact with the complainant. And this will run concurrent with 2021 CR 4750. Next, we're going to proceed with 2021 CR 4750. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Angie Marie Ford who was placed on deferred adjudication in 2021 CR 4750 for the offense of possession of controlled substance, penalty group 1, 1 to 4 grams, on July 20th, 2021 for a period of 3 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 25th day of April 2024 in Bear County, Texas. The defendant, Angie Marie Ford, committed the offense of theft of property greater than or equal to 2,500 less than 30,000 in violation of condition number 1.
To that, how do you plead? True or not true?
True. State will waive the remaining allegation.
All right, any objections to the state's waiver?
No objection.
Would you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Sure.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, sir. Proposed agreement. Motion finding this court and sentence to 2 years in the.
That's our agreement.
All right, are you asking the court to follow that agreement?
Yes, sir.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court will sentence you to 2 years and the court is going to revoke, find you guilty, sentence you to 2 years in the prison. Was restitution ever paid to the complainant in that case?
Judge, I don't have any restitution listed.
All right, there's to be no contact with Richard Osborne. Or the court will give you credit for any time served, credit for any time served for successful inpatient treatment. This will run concurrently with 2025 CR 005635. Is there anything else with regards to sentencing in that cost number?
No, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, and because your other matter is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you, okay?
Thank you. Do it, Your Honor, one more thing.
Yes.
What is this?
It's an apology letter to my family, that I wanted to thank you, because without you sending me to that program, I wouldn't be able to, reach out to my kids again. They're 23 and 27, but it's an apology letter to my family that I'm gonna, for them. But I just wanted to thank you for giving them their mother back.
Oh, you're so welcome. And I'm so sorry. Sometimes cases just drop on us. And if we would have known about the case beforehand, then that could have been taken beforehand. But here's the thing. This is just another bump in the road, right, of life, which happens to a lot of people. But you're going to have to stay on track with where you are. And don't let this derail your sobriety or derail the newfound relationships you have with your children, okay? When you're released from prison, if you can't find a sober living home or something of that nature, and I'm still here, just come back here. I'll pick up the phone and call somebody.
That's what I would like to do, is find a faith-based transitional sober living place to be able to get back on my feet. I've got my peer support certification while I was in SAP to run peer support programs. And the peer recovery specialist is what I would like to do to help women like me get back on their feet and be productive women in society again.
Well, stop
and
by.
that is due to you. And I wouldn't have received that program if you would have given it to me any earlier. I was ready for it. And I want to thank you so much for making that decision that I couldn't make for myself.
Oh, you're so welcome. And it's going to be great, right?
Yes.
Yeah, you have a lot now that you're clean and sober. Is there something for me?
Yeah.
Okay.
Thank you.
Thank you,
You're
Judge.
welcome.
All right, good luck, Angie.
All right, friends, let's stay in Texas, but let's go back to Judge Stevens.
You're Kobe James Rogers.
Yes, sir.
And Mr. Matuska is here. Mr. Matuska is going to be moving on to the federal government here shortly. So he's not going to be able to represent you anymore. What we're trying to do is see what kind of case, right now the state seems to be generous in making an offer to try to resolve this if we can. If we can't, the court's not going to accept anything. We just go to trial. That's what we do. What is
This is Mr. Hams. He's out on vacation today. I don't see an offer written down in his file. Let me see if there are the notes on the computer.
Yeah, this is a first degree felony of aggravated sexual assault of a child. So it's In this one, it's a felony of the first degree, but the minimum term of imprisonment is increased to 25 years if the victim of the offense is younger than 6 years of age at the time. And that's what this indictment alleges. So if convicted, you're looking at a minimum 25 years in prison to life. And is there even parole for this? I'm not sure there is. I think this is all day for day.
There's been a previous offer made of 15 years by dropping the super element of the offense, which would be the age. I
Have you
think.
talked about that? Okay. No. All right, then the court accepts no deal. This goes to trial. Another attorney will be representing it. That's all. And no deals. We try it. And try to get this one first. Don Sabi and Sam. These are all terrible cases. Okay, are you Don Xavier and Sam? Yes, sir. Is that yes? Yes, the here.
Yes.
Okay, good. You were here, Mr. Matuska is your attorney. He is moving to the federal government and he's going to be working with the United States from here shortly. So he's no longer going to be able to represent you on this. You've got this indecency with a child in 23 CL 626, carrying with it up to 20 years imprisonment and a first degree felony of aggravated sexual assault of a child, which carries with it no less than 5, no more than 99 years or life imprisonment. And these would be tried. Court would try these separately. So if you're convicted of each of these separate acts alleged here, because they're alleged to be, the crime was committed in different methods, then those, whatever sentences you would run, the court would order consecutively by law, if allowed. We're trying to see if there's any way this is going to be resolved. Trial, because this there would be no, that's where it still is?
Yes, sir.
And on which one? On the indecency?
It was a 20-year offer to run concurrent at this point on both of them.
Okay.
Mr. Sam rejects this.
Try it. And mark on the file, no deals. Your Cortez Zachary? Okay, we got today, what we're trying to do is to see if cases can be disposed of without a necessary trial. Mr. Matuska is moving on to the federal government. You have several cases. He's going to have to be replaced by another lawyer, but there are 8 cases here which include 23 CR 204, aggravated assault with a deadly weapon, which is enhanced because of prior conviction. Stand by. This, with the prior convictions, it's indicted as an habitual felon status, so you're looking at 25, minimum 25 to life on that one. On 23 CR 205, that's a first degree felony with the same prior convictions, so that's another 25. 23 CR 206, unlawful restraint, state jail felony. And there are those same prior convictions. So that state jail felony is punished as though it were a second degree felony. So that carries with it up to 20 years imprisonment. So 2 lives maximum and a 20-year maximum. 23 CR 207 is a first degree felony of aggravated assault with enhanced to habitual felon, 25 to life on that. 23 CR 208, first degree felony. And that is enhanced with the prior convictions, 25, a minimum 25 to life on that indictment. 23 CR 882, state jail felony with the sequential prior convictions, so that is enhanced to second degree felony. Possession of 24 CR 476, illegal possession of a controlled substance, a second degree felony. And they allege all those priors, so that's enhanced to habitual, 25 to life on that one. 24 CR 477, state jail felony, controlled substance possession, enhanced to second degree felony. And finally, state jail felony, controlled substance, enhanced to second degree felony. So what is it? 3? Four.
3 or 4 that are
4. Well, the least you're looking at are second degree felonies. And there are 3 or 4 habitual, 25 to life. So, it's overwhelming, but.
So the offers 25 on the habituals that are third degrees or higher, that enhanced to the habitual, and dismiss all the state cases enhanced to second degree.
The minimum.
Yes.
You're offering the minimum.
Yes, sir.
Concurrently.
Yes, sir.
And then dropping the others.
Yes, sir.
What do y'all want to do? This is the day. This is the day to decide, because a couple people are doing something. This is, the court doesn't entertain a deal after today. We're trying to resolve them. If we can, we can. And these would all run concurrently. So otherwise, the other ones are going to get stacked if you're convicted. What do you want to do? Okay, no deals. And we'll try the first degree felonies one at a time on the 25 to life. Let's see which one first.
There's some heavy stuff going on in Stevens Court today, and people not taking deals when they probably should, and all sorts of years in front of them. I don't know. It's got to be tough being in that position to say, yeah, okay, I'll take 25, and trying to get it through your head that that's the better bet. I don't know. We'll wait for another contestant there. In the meantime, back to Judge Boyd.
The court is calling 2024 CR 9-2 State versus Linda Flores. Can I have parties announced?
Martin Gatto, attorney for Linda Flores.
And are you Ms. Flores? Did you review the document entitled State's Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Probation with your attorney?
Yes.
And did you understand it?
Yes, ma'am.
Are you the same Linda Rose Flores who was placed on deferred adjudication in 2024 CR 0492 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on April 15th, 2024 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number, and this is on, I'm sorry, there, on state's motion dated May 21st, 2024.
Okay.
Violated condition number 45 on or about the 19th day of May 2024 in Bear County, Texas. The defendant Linda Rose Flores did then and there fail to successfully complete residential treatment at the Lifetime Treatment with Pay It Forward Sober Living as directed by the court in violation of condition number 45.
How do you plead to that? True or not true?
True. And then the motion dated April 15th, violated condition number 4 in Bear County, Texas. The defendant Linda Rose Flores did then and there fail to report to the supervision officer as directed for the months of May through December 2024 in violation.
How do you plead to that? True or not true?
True. State will waive the remaining.
Any objection to the waivers?
No objections.
Did you understand by pleading true to violations 45 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violations 45 and 4?
Yes, ma'am.
Court will find 45 and 4 true. Is there a proposed agreement?
State would be asked to plead to grant its motion to revoke, enter an adjudication of guilt and sentence to 4 years in the prison, and this is grounded in the fact that she absconded from drug court failed to report.
All right.
Your Honor, respectfully, we're asking you to deny the motion, continue her, and then alter and amend with placement in DDRF and mental health initiative following that. Your Honor, when this case was originally picked up, when she's placed on deferred, it was a chaotic time in her life. She was homeless. She had, unfortunately, an addiction problem with meth. And then her mother became ill. That's actually what prompted her to stop reporting, because she went to go leave the program and then take care of her mother. This is not a situation where she's been basically picking up new cases or out in the streets. She's been living with her mother and has been her full-time caretaker. Her mother did pass away this past December, however. I think the best way to make sure that these choices, these bad choices, don't get made again is in that structured environment with DDRF. So I'm hoping we can go ahead and place her there rather than just revoke.
All right. So, Ms. Flores, it's the court's understanding, and counsel, if I'm wrong, correct me, please. Felony Drug Court has a dual diagnosis program. So that addresses mental health issues and it addresses drug issues. But it appears from your pleas of truth that you just left. Am I correct in that? So I just don't, there's nothing else I can do. Felony Drug Court is an intensive program and they work with people. And according to your pleas of truth, you absconded. So I am going to find you guilty and revoke. I'm going to sentence you to the 4 years in the prison, give you credit for any time served, and the court will request the therapeutic community. Here's the thing. One, I know you want it to be continued. Sometimes people reach their epiphany, just sometimes it's too late. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Okay. All right. We can go off the record. Here's the thing. When you're released, if you can't find help for sober living, if you can't find help for any type of mental health condition, if I'm still here, you come back here, I'll pick up the phone and call someone at a transitional home that will address any mental health issues, any substance abuse issues, so you can have a placement that can help you. The therapeutic community, I don't have jurisdiction to force them to accept you in the program, but they'll see in the judgment that I'm requesting that for you and they can help. But you'll have to request it as well, okay? All right, good luck to you. Thank you. You're welcome. Who's next?
So you're asking in the chat about the drunk lady with McNally. She was there. I'm trying to get that queued up now, so hang tight.
Are there applications? All right, the court is calling 2025 CR 014704, 2025 CR 014703, State versus Edward Castillo. Could I have parties announced for the record?
Brandon Prater with the state.
Judge, good morning. Frankie Sandoval on behalf of Eddie Castillo.
And are you Mr. Castillo? All right, counsel, in each of the cause numbers, did you review the document entitled trial court did you review all of the discovery?
We did, Judge, in both cases.
All right. And you reviewed that with your client and you received all discovery?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Castillo, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment in each cause number?
We do, Judge.
Mr. Castillo, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, in each cause number, you're charged with assault of hospital personnel on hospital property as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you're giving up those rights?
Yeah.
And did you intend to give up those rights and enter into a plea in each cause number? All right, counsel, I don't have the application for community supervision. You're all applying for probation, correct?
Yes, Judge, and I apologize for that.
All right, if you'll grab them and sign those.
Thank you, Judge.
Okay. Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I think that he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Castillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine to be probated, and the cases will run concurrently. Did you understand that to be the plea? Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney in each of the cause numbers? Did you sign it in both places? According to, signing and entering into this plea, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, were there any such motions?
There have not been, Judge.
All right, outside the agreement, the state is recommending that your community supervision be for a term of 10 years. They're saying no contact with Methodist specialists in transplant, anger management, MRT. They're asking for inpatient treatment for what?
Judge, this all stemmed from an emergency detention while he was being detained.
No, I mean, you all are saying inpatient treatment. I'm trying to figure out what program are you all suggesting?
Safety, Judge.
All right. And there's to be no contact with the complainants. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
In each cause number, did you review the documents entitled trial court certification? I'm sorry, in each cause number, sorry, Cindy, I'm gonna slow down. And each cause number, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
No objections, Judge.
All right, in each cause number, the court will find there's sufficient evidence to find you guilty. The court will find you guilty in each cause number. Was there a referral? Do y'all think there should be a referral to the mental health court?
Your Honor, this was a bad evening for Eddie. Medication was an issue. Since he's been incarcerated, medication has been stabilized. I've been working with Eddie for a little bit over half a year and seen a drastic change in him. We believe, Judge, subject to the court's approval, that SafeP would address what's needed with respect to Eddie at this time.
All right, so do y'all want him referred to felony drug court? I'm sorry, not felony drug court, referred to the mental health court. Because if I'm looking at this, this is an emergency detention, which suggests to me there was some sort of mental health crisis.
The events giving rise that evening, yes, Judge, over at the hospital.
So do y'all want to have him referred to the mental health court? That may be the appropriate placement. Because as far as him going to SafeP or anything of that nature, he would need a TAP evaluation for that anyway. I can reset this, reset it for a TAP evaluation so we can see if SafeP is appropriate. They may say it's not. And then we could do a referral to the mental health court. And with the referral to the mental health court, of course, the state would have to agree.
Yes, Judge.
But the facts that I'm reading, he was suffering from a mental health crisis or in crisis, and that's why there was an emergency detention. And during the emergency detention, personnel was injured by him. So is there any objection to resetting this for him to have a TAP evaluation done? Because they may say SafeP is not appropriate for him, and then do a referral to mental health court.
Your Honor, on behalf of Eddie, no, there would be no objection. He's seeking whatever assistance he can to overcome these demons, because as the court is aware, the mental health issues bring along other potential difficulties.
All right, so what we'll do, Ms. Abrams, we'll set it for a TAP evaluation. And if the mental health court accepts him, then they can do the TAP evaluation. All right. All right, so we'll reset this for the TAP evaluation. How long will that take?
Judge, I need at least 4 weeks.
All right, so we'll recall it in 4 weeks. Norma, could I have a date?
March 18th.
And Judge, for the record, and I apologize, Judge, I may be out of town until the 18th, if it's possible to do the next day or the following week.
Okay, sure.
Okay, thanks.
23rd.
All right, we'll set it on the 23rd.
Thank you, Judge. And for the record, Eddie and I have discussed that even though he is agreeing, because of the state's generous offer to community supervision, there would still be a requirement for him to remain in custody while we go through this process. So
Yes.
he's aware of that. And then also, Judge, for the record, just to clarify, motions were filed, but nothing was ruled upon. They were just discovery motions, et cetera.
All right, thank you. So what we'll do is we're going to bring you back on March 28th, and we will have referral to mental health court and see if they accept you. Maybe they will, maybe they won't. The state has veto power with whether or not you're in that program. But it won't be in vain because we'll still get the TAP evaluation done.
Next stage on the same track.
Okay.
All right, so much. You're welcome.
Judge, what date was that?
I think you said March 28th, right, Norma?
No,
Oh, sorry, March 23rd.
Judge, on that date, they have that mental health conference. Do you want me to
Oh,
I just looked it up right now.
yes, put it after the mental health
The
conference.
30th, which would be the 30th.
All right, we'll put it down for the 30th, but of course, council, if we know before then that they're accepting him, we can still move forward with the mental health. It's just that on that date, I have to go to the mental health conference.
Thank you, Judge.
All right, thank you.
Okay, friends, you were asking about the drunk lady from Judge McNally's court the other day. She did come back today, and I'm going to show it to you here in just a second. It was in two parts. Just to refresh, this was a lady who showed up who had been drinking the entire night prior, and you could smell the alcohol on her. He had her tested, and she blew a .166 while in court. So he set it back, like, what was it, a week or two, and now she's back today. Again, this is in two parts, so let's see what's going on here.
On 30A and B, your name? You weren't drinking today or last night, were you?
No.
Are you sure? John, did you go near here?
I didn't smell
You have the right to an attorney. I'm going to give you an attorney. Okay? And then you can talk to your lawyer, and either way, when he's done talking to the prosecutor, you two are coming in front of me. Okay? All right. Good luck.
So that was just the short intro piece there. Now let's go to when she comes back with her lawyer. Again, this is from earlier this morning.
Hey, ma'am. All right, counsel, for purposes of. All right, and now she's going to plead to operating while visibly impaired. The super drunk will be dismissed, and she's also going to plead to.
The B charge with dismissal.
Okay, and then they're dismissing the improper lane use as well, correct?
Yes.
If you plead to impaired, man, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service costs, or all of those. 4 points, license suspension, revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, I do.
And did you sign an advice of rights form here today and read it and understand it?
Yes, I do.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Guilty.
No.
I didn't ask you that.
Understand, when you take the plea, that you're giving up the rights, and the advice of rights.
Do you understand what I said? Do you?
Well,
If you plead guilty to operating while impaired, you're giving up all the rights on this advice of rights form, and we're not going to have a trial. Do you understand that?
yes,
All right. Is that what you want to do?
yes,
To the charge operating while visibly impaired, how do you wish to plead?
guilty.
Were you operating a motor vehicle on Van Horn near Hall Road in the city of Flat Rock? I'm sorry, in the city of Woodhaven on January 5 of 26.
Yes,
Prior to driving that vehicle, operating that vehicle, did you consume alcohol?
yes.
What did you drink and how much?
I was drinking beer, and
How many beers?
about 2 to 3 beers, always.
Regular beer?
Well, it was ice. It was ice beer and a lot of water content. And
Okay, slow down. Keep your voice up. I didn't hear a word you said. How much did you drink?
about 2 to 3 beers.
And what kind of beers were they?
They were ice beers.
I don't know what a nice beer is.
It's got water alcohol.
How big was the beer?
It's just a little bit bigger than a 12.
So like a 16 ounce?
It was 4.
They call it a tall boy, Judge.
All right, so 24 ounce, you had 2 of them? I'm sorry?
2 to 3.
2 to 3, maybe 3 or 4? No?
No,
And then you operated the vehicle, right?
yes,
And was your ability to operate that motor vehicle impaired because of the consumption of the alcohol? And if so, in what way?
yes. I was swerving.
You think you were swerving at least in part because of your alcohol consumption?
Yes,
Did you take a breathalyzer test or a blood test?
yes.
Which?
She did a rough.
All right, and then toxilizer test, and were the results of that 0.166?
Yes.
You-
Actually, Judge, that was the PBT. The breathalyzer came in at 0.21.
Okay, and you stipulate that the 2-1 reading was an accurate reading for purposes of the plea?
Yes.
Are you on probation or parole, ma'am?
No.
Anybody in the world force you to plead guilty?
No.
Plea is accepted to that charge. I find it to be an accurate plea, made voluntarily and understandingly. The plea is accepted. To impaired driving, I'm dismissing on motion to prosecutor the improper lane use and the operating while it's actually a super drunk charge, so I'll dismiss that. Motion to prosecutor. I'm going to order a screening and assessment, and I'm going to set a bond. I'm going to set a $1,000 personal bond. I am mindful of the fact that you showed up to court drunk. That tells me that somebody has a problem. I'm going to order, she showed up to court the last time drunk, where I couldn't even arraign her because she had a 166. That's why I read that. I forgot about that being the result on the previous PBT. No contact with prosecution witnesses. I want you going to AANA 3 times a week. We're going to hand you a form. You have to go in person. Every time you go, you have to have the form signed. No alcohol, no illegal drugs, no marijuana. And you are to be on a SoberLink device by the end of the day. That's a breathalyzer machine, essentially, ma'am. Probation's going to explain it to you. You're going to be on, ma'am, I want you to listen to me. You're going to go out to Macomb today or Macomb County and get a SoberLink, and you have to do it by the end of the day. You understand me? Yes?
Yes.
AA 3 times a week in person. You understand that?
Yes. May I add something?
Sure.
I'm on the list for Oakdale to go into alcohol residential.
Well, that's great. But you're gonna, in the meantime, you're gonna get this SoberLink device, and I'm gonna expect to be blown in that machine unless and until I change the bond. Okay? Give me a screening and sentencing date, and you're gonna go next door, probation, fill out a questionnaire and be interviewed. We'll give you a sentence date. If you're still in Oakdale, we can do it on Zoom. So you'll have to stay in touch with this, okay? Or I could set this out 4 weeks if you want, Heather.
We could do that, Judge. If you want to go to the 18th, we could do it at 8:30.
March, what, 18th?
18th, yes.
At 8:30. That will be your sentencing date. Do you fully understand everything I've just said?
It's a lot to, it's a lot to absorb.
No alcohol, no drugs, no marijuana. You're going to AA 3 times a week in person. You're going to go figure out where you're going to go. Probation's going to explain it to you. Listen, you're going to get a SoberLink device. You have to be on a SoberLink device that you are blowing into by the end of the day. Do we understand one another? Do you understand?
Right.
Yes?
Yeah.
And no contact with prosecution witnesses. So you go down the hall, get your notice, go over to probation. They'll explain where you have to go to get your SoberLink, okay?
And Judge, I'm also printing up a register, and it will have everything she needs to do on there, and I will highlight it for her so she understands it.
Thank you.
You can go to probation. Once you come here, you can go to the social.
Are you all right? You all right?
Yeah, I'm just nervous.
All right. I mean, you have a reason to be nervous after showing up drunk last time. Do I have Guy Neely?
It wasn't just showing up drunk last time. It was claiming she was the 11th cousin of the president and deserves some kind of immunity for it. I did tell you guys I have to cut loose early today, and I do, but we're going to do one more hearing with Judge Boyd before we go. And judging from the stats, a whole bunch of new people just showed up. So if you haven't been here before, say hi in the chat. This is a very good community. Let's go to Judge Boyd for one final hearing.
All right. Nine state ver-
the ISF part, if
Stevie,
that
did we,
makes sense.
did we go over them to you
I
already?
know, but,
All right, so let me explain something to you. I don't know what type of agreement y'all have maybe worked out. But these motions to revoke, when you're on probation, is a contract with the court itself. Any agreement that's worked out by the state or the defense, I don't have to follow it. So what I'm trying to get at right now is this is your motion to revoke. All right, did your attorney review the motion to revoke with you?
no,
Okay,
all right.
Can we reset? I gotta go to Carnes.
sure. All right, Ms. Ferguson, if you can recall this for Thursday. All right, we'll see you back on Thursday.
Thank you.
Thank you. All right, thank you. All right, who's the other person with the all right, Austin Rodriguez. All right, if you'll come forward, please. Court is calling 2025 CR 012329 State versus Austin Rodriguez. Can I have parties announced for the record? For the state. For the defense.
Good morning, Judge Alfonso Cabañas for the defendant.
And are you Mr. Rodriguez? Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there's an application. Did you review the application for community supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Mayor, statements to waive the habitual influence.
Any objection?
No objection, Your Honor.
Oh, my pen just died. All right, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with unlawful possession of a firearm by a felon? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Rodriguez, did you understand I'm sorry, just one moment. Fine. The state is opposed to your application. They're taking in consideration 2025 CR 012326. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objection to states one and attachments.
Right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right. Senate PSIs are taking about 12 weeks. So if you want a full PSI, I'll give you a reset date in 12 weeks. Or if you do not wish to have a PSI, but you want a chance to bring witnesses in, I can give you a shorter reset.
I do have quite a few characters.
Oh, you just let me know. That's, I mean, if you, I'll reset it in 12 weeks. That means that probation will interview you. They'll give me your criminal history. Someone will come visit you at the jail to interview you, okay? All right, thank you.
Thank you, Judge.
Dicker. Yes.
Okie dokie, friends. As I said, I need to call it a day, an hour early today. We will be back tomorrow, though, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. I hope you all had a good time today. I did, but look forward to seeing you tomorrow. Go have yourselves a great Wednesday. In the meantime, take care. God bless.